cited these very provisions in our skeleton argument. And I think it's paragraph 32 of his judgment where he refers to the code. And the idea that just because he doesn't specifically refer to the bit about disclosures of information, we say is for the birds.
What was the change from Campbell?
Well, it's a fairly minor change, but I think it's the way in which it's the way in which the editor is required to justify the intrusion is very slightly different. I'm just struggling to find my copy of Campbell. Oh, yes. Can you just give me the paragraph number? It's 393. A publication will be expected to justify intrusions. And then, so there's a small difference there. When one gets to the public interest, non-exhaustive public interest examples, there may be exceptions to the clauses marked asterisks where they can be demonstrated to be in the public interest. 3, protecting the public from being misled by an action or statement of individual organisation. That, I have to say, doesn't seem to be materially different. I think it's probably just the difference between the publication and the editor, or editors, I should say, in the governing wording of clause 3 under 2. But the first point is, as I say, there can't be any serious doubt that the judge had those provisions in mind, and indeed the reason we relied upon them was precisely because it could not be fairly said that the claimant had put the private information of which the contents of her letter consisted into the public domain, nor was she about to at the time of the defendant's publications. So, applying the code told against the defendant, not for it. I do have a slightly different point in relation to the book, which I'll come on to. So, my Lord, that's just a brief word about the ipso code. Before the adjournment yesterday, we were dealing with the judge's analysis of what the article said about, what the People article said about the letter, and what the defendant could arguably, justifiably say published from the letter in the light of that. And another document which was before his lordship, which might be of assistance to you, was a schedule to our skeleton argument, which we relied upon as helping to demonstrate the limitations to the case of inaccuracy in the People article. It's in it's at page 190 of the supplementary bundle. I hope the court will find a colour version, a coloured version of what is described as Schedule A. Comparison of People article with letters. And the starting point...
which page is it?
SB, Supplementary Bundle 190.
190.
I'm so sorry. What?
90, sorry.
Black and white, still.
I'm so sorry. That's. Perhaps I could hand up 3 colour versions, because
it any different to the colour on the screen?
You should have yellow first colour, green highlighting I love you, and
blue.
then blue please stop victimising me, and then purple
Yeah, what's the code?
I'm grateful. So
What's the code?
um,
What do the colours mean?
we're distinguishing between different items of information in the letter and their analogous references in people. And the point of the exercise was to show, as hopefully as clearly as possible, just how minor the inaccuracies in substance were in the people interview.
The judge said that.
And he did, and just so your lordships have it, because it I think demonstrates graphically just, if I may say so, how right he was. Because those three components in the top left of the table, I'm so heartbroken, I love you, please stop victimising me through the media, they are all present in the letter in the ways that appear from the extracts that we have highlighted in the middle column under relevant content of the letter. What is missing, as we accept it, materially, is the last words in the extract from the people interview, so we can repair our relationship. And we accepted that that was not an accurate characterization of the purpose of the letter. And I made the point yesterday that the last sentence of the letter itself, in paragraph number 15 in the judgment, which is reproduced at the bottom of the first row in the middle column, I asked for nothing other than peace. That wasn't reproduced in the letter, and in fairness to my client, if a point was going to be, if the articles were going to be used to rebut, or I should say correct, the inaccuracy that there was about repairing the relationship, one might have expected fairly that the extract from paragraph 15 would have included the concluding words, which were not a million miles away from repair our relationship. I accept it's not an olive branch, but it is germane. And then in relation to the photo op, for completeness, in the second row, there are the references in purple on the left-hand column to the people interview, and analogously the references in the articles quoting from Mr. Markle's letter, of course not our letter, which we say perfectly, substantially match what he himself had said, what people on interview says substantially matches what her father had said, and the judge dealt with that, we say, appropriately in his judgment, making the obvious point, of course, that this is not her information, it's his information, and he was entitled to publish it, as indeed he did in the articles, but it doesn't assist on the question of what the defendants could justifiably publish in relation to the claimant's letter. And before I move on to what I anticipate to be the defendant's argument on this area, which was something of a radical submission that emerged yesterday, could I try to test the general proposition on deployment of the letter in this way? If one had stripped out from the people interview, in that 25-word passing reference to the letter, if one had stripped out the words, so we can repair our relationship, what could plausibly or arguably justifiably the defendants have published from the letter? We say nothing. The submission that we understood, if we've noted it correctly, Malone and Friend to make in relation to what could justifiably be published from the letter, was that it doesn't matter that the letter was not in the public domain. I think the way he put it was, if the letter makes a serious allegation against Mr. Markle, and he's entitled to reply, and we are entitled to carry the reply, the fact that the text has not hitherto been in the public domain has very little to do with it. With great respect, we submit that just cannot be right as a matter of principle or on the facts of this case. The idea that you're entitled to bring into the public domain the contents of a private letter just because the letter makes a serious allegation against Mr. Markle, assuming for present purposes it does, we say simply cannot pass muster, completely contrary to basic principles of privacy law. It also begs far too many questions. Setting aside just what allegations that the letter did make against Mr. Markle, learned friend says he's entitled, and if he's entitled to reply, well, what he's entitled to reply to is the public attack. That's the ipso justification that the defendant was invoking. It was correcting the record, put more properly.
I thought he accepted that, and I thought he said that the response was to three things the judge did not emphasise from the People article, which was partly the olive branch, and then the allegations about the wedding.
Yes.
And I thought that's what he said.
Yes, I think it's tied in with the wedding allegation, but we say it just doesn't, logically it doesn't work. One has to...
Well, I don't really understand, because I'm not sure that the letter said anything different about the wedding to what the article said. I mean, the article said that the Duchess had behaved entirely properly in relation to the wedding, and so did the letter.
Yes. Well, my Lord is quite right. What the letter does, the letter contains a detailed account of all the ways in which, in her view, her father's conduct had to use her phrase, broken her heart. Mm-hmm. And those included a number of different topics, including the lying about the staging the paparazzi photographs, that he hadn't returned the 20+ calls, and that he spoke to her only through the media, and there was a bit of reference to the wedding, but as your Lordship says, there was nothing about the very narrow reference, which I think is now being elevated to some importance, about him not getting into the car when the taxi was provided for him to go to the airport. If that's really what it boils down to, I'm afraid to say I simply don't understand the submission, and it doesn't work as a matter of principle or as a matter of logic. On reply to attack, I'm very anxious not to waste too much time on this topic, because my learned friend did concede that it's just a question of public interest, right to correct the record. That's the relevant heading. He did refer to Adam and Ward, but even if somehow the common law principles of qualified privilege, reply to attack, were to be thought to be relevant, they wouldn't help either, for the simple reason that, first of all, the attack has to be the attack cannot be a false or unjustified one. And indeed, in Adam and Ward, that was precisely the factual basis upon which the court upheld the privilege, that the plaintiff admitted that his attack on, it was actually a third party, not the defendant, was false. But it goes further than that, because it's quite clear on established authority that for this sort of privilege to exist, the reply has to be fairly relevant and proportionate to the attack. And my Lord Justice Bean, I think, has dealt on the High Court bench, I think, with a couple of cases where this very issue was visited as a matter of law. But there's absolutely no doubt that all it does, it doesn't help. All it does is bring us back to the same questions of proportionality and relevance. And again, for your lordships and your ladyships, note we've put in the reference from, there is a reference from Duncan and Neil, it may have been Malone and Friends who wanted it in, towards the very end of the second authorities bundle at 1086, tab 43, 1086. Under reply to attacks, paragraph 17.25, I think I can just pick it up in the third sentence. Provided that such statements are fairly relevant to the rebuttal of the attack, and the ambit of their dissemination doesn't significantly exceed that of the original attack, their publication will be the subject of qualified privilege. And then there's a reference to Adam and Ward. And what is said in Adam and Ward in the citation, which I think Malone and Friend did refer to, but by reference to the authority, about, this is the third line from the bottom of the citation, if having regard to all the circumstances of the case, he might have honestly and on reasonable grounds believed that what he wrote or said was true and necessary to the purpose of his vindication, although in fact it was not so. That's all predicated on the assumption that the reply is fairly relevant and proportionate. And one sees a more modern reference in footnote 5 to Mr. Justice Eadie's decision in Hamilton and Clifford. If I can just pick it up at the end of the first line, he summarised the scope of the defence by saying that a defendant is entitled to protect his reputation by a proportionate response which is appropriate both in terms of subject matter and scale of publication. So the short point is that no trial court would be assisted by evidence from Mr. Markle of whether he honestly or reasonably believed that he was entitled to reply to the attack. Far less that he was entitled to reply in the terms that he did with all the extensive extracts from the letter. It's for the judge to decide objectively whether the interference, the assumed interference with the privacy rights of the claimant were justifiable, and that of course crucially depends upon proportionality and relevance, and indeed whether or not the attack was true, but that only is relevant if one gets past the other hurdles. Conceptually, the question of what a defendant might reasonably deploy of somebody else's private information as part of a public interest offence is obviously different conceptually from the question of in what language may a defendant defend himself against a defamatory attack. These principles are dealing with very different policy considerations, and we submit the court just is not assisted by reference to reply to attack. On the question of whether the test is objective, I had thought that it was common ground that both at stage 1 and stage 2 the test is an objective one. It's the judge directs himself in those terms in the judgment. If it is to be disputed, there is authority in the form of this court's decision in Ali versus Channel 5, which, if necessary, we can make available to the court.
I thought he said it was objective in paragraph 31.
He did. And
Mr. Caldecott accepts that.
If that's accepted.
What do you say, Mr. Rushbrook, about the contention that the judge confused public law and private law effectively, transposed the, I can't remember the number, I'm afraid,
The House of Lords, the Supreme Court, JR 38.
Exactly.
Yes.
Confused that with Campbell, and didn't really understand how one read across Article 8 and Article 10, where the parties were private and not public. public authority.
Yes. The nub of the complaint, if it amounts to anything, must be that JR 38 was a public law case where no other rights were in play, specifically Article 10 rights, whereas in this case there were Mr. Markle's and the defendant's Article 10 rights, and therefore, as I think it was put, the balance was skewed both at the stage 1 and the stage 2 test, because the judge misdirected himself by having regard to the very important difference between the rights in play. That cannot be right. If one looks at the...
Well, it's where the judge seems to have put a burden of proof on the defendants in relation to freedom of speech. And I can't give you the paragraph number because I haven't got it in my mind, but the judge, there's a sentence in the last, at the end of a paragraph, where he makes it sound as if the defendant newspaper has a burden of proof, whereas of course Article 10.2 is about displacing. It's the reverse of that.
Yes, well, my Lord, it's paragraph, I think, 30 of the judgment that your Lordship has in mind. I mean, the short answer to where I'm going with this is that when one looks at the judgment as a whole and all the places he refers to the exercise he's carrying out at the stage 2 test, it's perfectly clear that he is applying the relevant balancing exercise as a parallel analysis. He's not presuming anything in favour of the claimant or imposing an unjustified burden on the defendant. I'm sorry, it's paragraph 35.
35, yes.
35. What that reference at the end of the paragraph is to our submission before the judge below, which the judge, to be fair to him, is setting out. That, to be strictly, I think we probably need to divide it into two. There's the question of whether there's a burden of proof that the defendant is charged with. And then there's the question of whether the judge ignored the fact that there were Article 10 rights in play. On the first question, I think I did address this yesterday, but just so the court has our submissions clearly, this wasn't a case that turned upon the burden of proof, because if one looks at the painstaking analysis that the judge undertook...
Attention please, attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the anniversary of Armistice Day. Thank you.
So first point is reciting our submission, and our submission was itself a citation from ZXC and Bloomberg at paragraph 46. We don't need, I submit, to get into a debate about whether or not paragraph 46 of ZXC is binding on this court, or was it per incuriam because of its reference to JR 38. Because if one looks at the substance of this judgment, and indeed when he goes on at 36, he places no emphasis on the burden of proof, but he talks about the well-established two-stage approach in domestic law, and that the two-stage analysis is, however, a fair and convenient one to adopt. This is the framework that has been adopted by the defendant in its approach to the issues. And of course, one has to bear in mind also that this is all subject to the preceding paragraphs 30 and 31, and indeed 32, where he sets out exactly what that stage 1 and stage 2 process is. We submit impeccable form. Self-evidently, that there could be no suggestion that that summary of the principles at stage 2 was leaving out of account free speech rights of the defendant or Mr. Markle. They're absolutely fairly and squarely in play in paragraph 31. Again, one doesn't, I don't need, I think, to dwell on it too much, but at 32, of course, he does refer to the code of practice. And it is, as it happens, worded in the way that the court has seen, which does call upon the editor to justify its interference with the privacy right without consent. Now, I accept that's not a formal burden of proof, but it is nevertheless part of the architecture of our law, because section 12(4) of the Human Rights Act requires the court to have regard to the code. If one then moves on to the other bookend of the judge's analysis on stage 2, which is his conclusory paragraph at 1 to 8. It's quite clear, we say, and we say again, this is cannot be faulted in terms of his legal approach. It's quite clear that he's asking himself the right questions about the balancing exercise. He does so by reference to, as one sees, an objective review of the articles. And he concludes that the articles, save to the very limited extent I have identified, this is the middle of the paragraph, the disclosures made were not a necessary or proportionate means of serving that purpose. For the most part, they didn't serve that purpose at all. Taken as a whole, the disclosures were manifestly excessive and hence unlawful. No prospect that a different judgment would be reached after trial. The interference with freedom of expression which those conclusions represent is a necessary and proportionate means pursuing the legitimate aim of protecting the claimant's privacy. And forgive me if I'm repeating myself, but that reference to necessary and proportionate is an unexceptional way of putting the matter in the same way that Baroness Hale and Lord Carswell do in Campbell, where they use those themselves refer to necessary in a way which, as I say, is context is everything. This is essentially an alternate or a proxy for justified. And, my lords, if that isn't good enough on the judge's approach, there was criticism of 1064 on page 151, 106 of the judgment, subparagraph 4, whether the publication was necessary and proportionate in pursuit of the available justification, and then the reference to SICRI. If one takes, it's all very well focusing on subparagraph 4 and saying, aha, that's an inappropriate reference to necessary, and it's importing the wrong JR38 analysis. But again, one has to look at it in context. And the context starts at 104. And I think perhaps the most convenient way of dealing with it, would the court be good enough to read from 104 down to the end of 108, because it's very important to see all of the context in which subparagraph 4 of 106 appears. Looking at that as a whole, it's abundantly clear that everything that possibly could be said on behalf of the defendant that needed to go into the balance was put in the balance by the learned Lord Justice. And it's absolutely clear from 108 that he's making the very distinction between a private law and a public law case that my learned friend suggests he was failing to have regard to. I mean, the purpose of his citation, his reference to Campbell, is precisely, one might think, amongst other things, it shows he had very much in mind not just the defendant's Article 10 rights, but Mr. Markle's. So on any view, simply cannot be fairly said that this judge, who has vast experience and long experience in this area of the law, who expressly says that he has Campbell in mind, beginning of 106, proposition that he was applying the JR38 test or analysis, disregarding the defendant's Article 10 rights, let alone Mr. Markle's, is utterly hopeless. Before I leave that topic, at 104, could I just observe that the way he expresses himself is, we would say, absolutely alive to the need to put the burden, the bar at the right place from the defendant's point of view. He's not imposing too high a bar on the defendant, because he says the real issue on this part of the case is whether the publication complained of might be justifiable. Not even was, might be justifiable. And then at the last sentence, if there's a real possibility that the publication complained of might be found justified on this basis after a trial, I ought not to strike out or grant summary judgment. So as a matter of express language, both at 104, 106 and 108 in context and as a matter of substance, simply cannot be said that he misdirected himself in law and applied the wrong approach. On the use of necessary, even in the private law context, just so your lordships and your ladyship have the reference, Baroness Hale in Campbell says,
Which paragraph?
I'm so sorry, 152, that consideration, that's in other words the fact that she had publicly denied being involved with drugs, justified the publication of the fact that, contrary to her previous statements, Miss Campbell had been involved with illegal drugs. It also justified publication of the fact that she was trying to do something about it by seeking treatment. It was not necessary for those purposes to publish any further information, especially if this might jeopardize the continued success of that treatment. And again, Lord Carswell at 170, to similar effect, just picking up the last two sentences, I consider that that's the deployment of the photographs and additional material, constituted such an intrusion into the appellant's private affairs that the factors relied upon by respondents do not suffice to justify publication. I'm unable to accept that such publication was necessary to maintain the newspaper's credibility. The short point is that the use of the word necessary in Lord Justice Warby's judgment in 128 is no different to the use of the word necessary that one finds in those two speeches in Campbell. And I think a point was taken about the other paragraph that my learned friend fixed upon was 1255 of the judgment. It was neither necessary nor proportionate to disclose any of the rest of the information in the letter for this purpose. We say that's simply the judge doing exactly the same thing as Lord Carswell and Baroness Hale did in the private law case of Campbell. So any attempt to trip the judge up on the use of language, we say, must fail. On other errors of law, it's also said that the judge skewed the balance in favour of the claimant at stage one. And I think the way it's put is that he failed to assess the strength of the claimant's privacy rights. And that by failing to do that, in comparison with the rigorous weighing of the defendant's Article 10 rights, and indeed those of Mr. Markle, that he was in effect skewing the balance and requiring, setting the bar too high for the defendant. Our response to that is, well, first of all, nothing new in this submission. One can't pick through the bones of particularly a very, very long judgment like this and say that just because something isn't mentioned, it follows the judge didn't have it in mind. Again, as a matter of common sense, the idea that he was completely oblivious to or had no regard for the nature or strength of the claimant's Article 8 rights is very difficult to construe from the judgment as a whole.
Does it matter? Because in this case, it seems to be tacitly, not expressly, because Mr. Caldecott did say that she did not pass stage 1, but I think he didn't put that at the forefront of his submissions. So let's assume, for this purpose, that she did pass stage 1
Yes.
narrowly. Let's assume that,
Yes.
because she had put some material into the public domain. The Article 8 right was weakened by the circumstances, the various things that he relies upon. For summary judgment, you have to show an answer which Mr. Caldecott accepts is a binary question.
Yes.
Did you have a reasonable expectation of privacy or not?
Yes.
If you pass that hurdle, you must go on to the balance. If you then consider the balance and there is no reasonable triable issue which could show the balance to be tipped in the defendant's favour, then you are presumably entitled to summary judgment. Is that right?
My Lord, that is right, and that's pretty much the way that this court put it in the Prince of Wales case. I think I should just take you to that, because my Lord has already, if I may respectfully say so, rightly observed that this is an evaluative exercise that is on appeal. And the court will be more than familiar with the test that faces an appellant who's trying to overturn a decision of that kind, whether one calls it evaluative or exercise of discretion.
I'm not, I mean, with respect, I'm not entirely sure about that. If Mr. Caldecott shows that there is a triable issue that could not be determined on a summary judgment and needed evidence which would have been capable, had it been decided all his way at trial,
Yes.
would have been capable of shifting the balance his way at stage 2, he wins this appeal, whatever evaluation the judge made. Your submission, as I understand it, is he can't win that because the only justification for breaching privacy here by the defendant was either in the public interest or to set the record straight, and in both cases the People article did not demand the publication of the letter for that purpose on any analysis. That's what you say. And as I understand the case, if you're right about that, well, you're right about that. The appeal fails. So, I mean, I'm very keen to look at the Prince of Wales case, so I'm not trying to take you out of your course. But you said, I had said it was an evaluative exercise. The judge was actually looking to see whether the defendant could win.
Yes.
And he concluded he couldn't for the critical reasons in paragraphs 124 to 128.
Yes, my Lord, respectfully agree, and I don't think I could add to your summary of what the judge was doing, say possibly to say that he not only did he carry out the exercise that he did, but he did it expressly against the background of assuming in favour of the defendant all of the factual allegations that he felt, in his view, were arguably relevant. And I think I only need to refer to paragraph 23 of Prince of Wales, just so that the court can see the way in which it was dealt with there, which is precisely the same issue that's before the court in this appeal. It's page 611 of the second bundle. It's short and to the point. It's tab 26, second bundle, page 611. 23. For these reasons, we reject Mr. Warby's submission that there are issues of fact unresolved that call for a trial. The issue on this appeal is whether the judge's application of the law to the facts that were either undisputed or assumed to be those advanced by the newspaper produced the correct result. That is precisely the same question that arises here. I think all I really want, by reference to evaluative exercise, I wanted really to accept in my learned friend's favour that we're not just talking about an evaluative exercise at trial. We're talking about the one conducted against the background that the judge did, namely summary judgment, but crucially where facts are assumed to be true in favour of the defendant. So at that point, the argument must shift to the question of, well, did the judge leave out of account some arguable fact that he didn't assume to be true that might affect the outcome? Because if we are right, and he assumed in favour of the defendant everything which needed to be assumed for the purposes of the exercise he carried out, then the appeal is doomed, because on our submission, the defendant has not pointed to any error of principle or law or of approach in the exercise which, as the rule says, he carried out in detail on the balancing exercise. And for that reason, the submission that the balance was skewed at stage one really goes nowhere. On the question, the now topical question of what did the judge assume to be true in favour of the defendant, I think I said yesterday that there were numerous references in the judgment, and for your lordships and your ladyships' assistance, I ought to just take you to them now. And one sees not just how generous he was to the defendants at that stage, but we'll also see, when I come to it later, that the position factually has actually weakened from the defendant's point of view. I don't need to make that point, but it is important so your lordship see what's gone from the case, to see that in fact the judge was overly generous to the defendant. But on the stage one, at 66, he expressly says, two main questions. First, whether the defence sets out any case which, assuming it to be true, would provide a reasonable basis for finding that there was at any material time no reasonable expectation of privacy. A bit further on, nothing that the defendant has pleaded in answer to this part of the claimant's case provides any reasonable basis for defending the issue. 72. Last sentence. This is under factor one, the claimant's status. It's in my judgment impossible to say that the factors listed in the pleaded case or in submissions, assuming the facts were made out, could have such a significant bearing on the answer as to lead the court to conclude that alone or in combination with the other circumstances they deprive the claimant of any reasonable expectation of privacy. 77 to 78, still under stage one. This is factors 2 and 3. At 77, he summarises the defendant's plea in this respect. This is about father's intentions, or presumed intentions. And then at 78, halfway through, but even assuming the facts to be as pleaded, they are not capable of defeating the claimant's case that, objectively speaking, she had a right to expect her father to keep the contents of those rights may be ignored or violated. Factor 4, public domain, at 84. He accepts in favour of the defendant. In fact, we say wrongly, he accepts that the authors were given a copy of the letter, even though it's not pleaded. Before reaching, we say, the correct conclusion is, it doesn't matter how the quotations got into the book, all that matters is the timing and extent of publication, which is plainly not enough to defeat the claimant's rights against the defendant, even from the date of the publication of the book. 86, under the heading of other disclosures or alleged disclosures by the claimant, it's a zone of privacy argument. This is effectively, I think, gone from the learned friend's submissions anyway, but again, last sentence, it is in my judgment fanciful to suppose that a court might find after a trial that any of the other disclosures or alleged disclosures, alone or in combination, place so much relevant information about these matters in the public domain that the claimant lost any right to privacy in the contents of the letter. So again, assuming in favour of the defendant that it might make those out. 88, this is under the claimant's intentions as opposed to what she's supposed to have expected her father to do with the letter. Now, I do stress that much of this case is now gone, but 87 sets out what the line of argument is. The pleaded case, this is the second sentence, is that the court should infer that the letter was written and sent with a view to it being read by third parties and or disclosed to the public, alternatively knowing that the same was very likely. Moving down to the bottom, towards the bottom of this paragraph, an inferential case is advanced that the claimant was considering using the letter as part of a media strategy to improve or enhance their image. And then at 88, he goes on to say, it's fair to say this inferential case is not very precise or clear. It doesn't appear very compelling. If your lordships and your ladyship would just read on to the end of that paragraph, and in particular the second, last and last sentences of that paragraph.
Five lines from the bottom of the paragraph. What did the judge mean by such information? Claimant is happy to have such information put out publicly.
That is a, I think that's a reference to the very long list of items of information that appeared in the book under 52D. There was quite a lot of factual dispute about this because we said they plainly were not information that could have come from the claimant, not least because so much of the personal information in the book was inaccurate. But setting that aside, this is part of a zone of privacy argument that Malone and Friend has now abandoned. So, short answer, what is it? It doesn't matter anymore. But that is what he's referring to. He's referring to the argument that you're happy to provide the authors of the book with a whole load of items of information regarding your family or your friends, and that disqualifies you or reduces your expectation of privacy in relation to the letter.
Has that been abandoned?
I think I understood my learned friend to say he no longer relies on anything other than disclosures in relation to the letter. But the point in 88 is that he is assuming in favour of the defendant that those disclosures to the author were made by her on her behalf, and he rightly holds that they are irrelevant because they're not in the right zone. It's fair to say that 88 is dealing with more than one aspect of the defendant's case on this. That's why it comes in under the defendant counters. Then at under stage 2, again, the introductory assumption is at 97 in relation to factors already relied on. Naturally, the defendant relies on the factors I've already discussed as matters to be taken into account at this second stage. Said to make the privacy interest slight or compromised any expectation. In my judgment, taking the defendant's case on each of those factors at its highest, there would be no real prospect of the court striking the balance against the claimant in favour of the defendant and its readers. I should say, my Lord, in response to Lord Justice Bean's earlier question, that the reference to the various items of information that appeared in the book, this is all in relation to stage 1, expectation of privacy, where it was, as we submitted and the judge accepted, utterly hopeless. But he's also assuming in their favour, for the purposes of stage 2, that those factors could be made good factually. At 99, this is important. If I could pick it up at the second sentence in relation to her status as a public figure. That interest would... it's not possible to imagine a court concluding that this consideration outweighs a claimant's privacy interest in the contents of the letter. That interest would, for the reasons given above, be bound to weigh heavily in the balance. Prior publication about its existence and nature, he goes so far as to say that, could weaken that interest somewhat. So might an intention to make public the same information at some stage. But the most that is alleged in these respects is that the People article was authorised by the claimant and that she passed information about the contents of the letter to friends and to the authors. As I've noted, the defendant does not plead that the claimant provided the authors with a copy of the letter. The prospect of the defendant obtaining evidence to support the hearsay evidence of Mr. Verity and contradict Mr. Scobie's witness statement on the issue seemed to me remote for all manner of reasons. I would class the notion as fanciful. But even if that were wrong, I cannot envisage a court attaching any great significance to this factor at the second stage. And that's an important passage because it deals with the complaint that the judge only made the assumption about provision of the letter or information about the letter in respect of the public domain issue. But he doesn't. He makes it fairly and squarely in respect of stage 2. And he doesn't just accept the defendant's case at its highest. He actually goes above and beyond it and accepts the possibility, which he regards as fanciful, that the authors were provided with a copy of the letter. Then at 100, he deals with 2 further factors: fact and content of the disclosures made to the authors for the purposes of the book and what these are said to show about the claimant's attitudes towards publicity for and about her private life and the private lives of others. Well, that, Lord, actually is picking up again on what was the subject of your Lordship's question at 88. The defendant invites the inference that the claimant is ready and willing to publicise details of her own private life and those of others, including correspondence, and that she doesn't object to publicity about her so long as it is favourable. These are matters which are hotly contested. I cannot possibly resolve the factual disputes which arise, but nor do I consider that these matters could supply the element that is otherwise missing from the relevant factual matrix. And he goes on at 101 to recite the law on zone of privacy. And importantly, in the second last sentence, a person who actively seeks the limelight may have a correspondingly reduced expectation of privacy, but the analysis must be focused, not broad brush. What is alleged here cannot be regarded, in my judgment, as a factual case capable of showing that the disclosures complained of contributed to a debate of general interest. And just so your Lordships and your Ladyship have a flavour of the sort of stuff we were talking about, we did spend some time on this below because we said factually the case was hopeless. there were various items of information which, I think there were 49 of them, which were pleaded out under 52D of the re-amended defence, which were demonstrably, as it happened, nearly all in the public domain. Some of them had actually come from the defendant's own articles on aspects of the claimant's life. But they simply were not capable, on our case, of doing the job of amounting to any significant disclosures of relevant personal information about her life, or indeed others' lives, such as to weaken her rights in relation to the letter. And that's what the judge is dealing with in this passage, even, we say rather generously, assuming in favour of the defendant that those references in the book could be laid at the door of the claimant. 102, again, he assumes implicitly in the last sentence of the paragraph that the claimant did provide the letter or information about it to the authors with a view to publication, or wrote it with a view to later publicity. But again, we say correctly, concluded that she would have been well within her rights so far as her own privacy is concerned. 107, in relation to the public interest justification for disclosure of the private information, specifically under the heading of correcting the record. 107, the judge accepts for these purposes that Mr. Verity's evidence would be accepted in full if there were a trial. And this is effectively the evidence of, I thought it was reasonable and in the public interest to publish all these extracts from the letter. He does endorse Mr. Markle's view that the People article misrepresented the letter, but he goes no further in the sense of factually standing behind any of Mr. Markle's allegations or rebuttals. It's effectively the sort of statement that one often gets from a newspaper editor saying, I thought this story was in the public interest, and that our readers would be interested in seeing all these extracts from the letter which were necessary to give a proper flavour and authenticity to the story. Judge accepts all that factually, but goes on rightly to alight on what really matters, which is whether, objectively speaking, giving due deference to editorial beliefs or considerations, the intrusion nevertheless went too far and was disproportionate. 113, this deals with the very, very narrow spat about whether or not Mr. Markle had refused to get in the car that had arrived to take him to the airport. This is contested, but assuming this to be true, it could not provide a rational or arguably proportionate reason for disclosure of any part of the letter. Whether my learned friend agrees with that conclusion or not, and it's for this court to say whether or not there's anything in the objection, it cannot possibly be said that the judge failed to have regard to it. I think that is it in terms of references to the factual basis being assumed in favour of the...
Did he deal with the question of the wedding, the events of the wedding, and the letter being published as a rebuttal of what was said in the People article about that?
Well, my lord, it depends what one means by events of the wedding, because yes, insofar as they were put to him, is my short answer. we can't find anything in his analysis, anything missing from his analysis that was submitted to be of arguably important relevance on the balancing exercise. Sorry? On the question of the texts, he does, and he was taken in some detail by me to the texts. He expressly refers to the text messages that passed to and from in the lead up to the wedding. They are included in subparagraphs 1 to 8 of paragraph 40. And could I just say on the question of the text messages, one thing that we didn't understand to be in dispute was that the conversation that took place a week before the wedding, when the claimant has learned of the forthcoming Mail on Sunday article, no dispute that conversation took place between the claimant, her husband, and the father. And we didn't understand it to be disputed, that Mr. Markle was not truthful to them when he denied that there was any truth in the paparazzi story. The real point is that that doesn't matter, because when one looks at what the letter says about it, she gives chapter and verse on what did happen. And I took you to the reference yesterday in the letter towards the end, which ended up with the CCTV footage coming out. I can't remember whether she actually used the word lied, but there's no doubting that the factual account that she was putting forward in the letter, and therefore for the reasons that we were considering yesterday, it couldn't possibly serve to justify any public interest defence to deploy parts of the letter that, as it were, told her version of the truth. That his preface to paragraph 40, he notes that there is a level of dispute as to the precise sequence of events, and that the defence presents a somewhat different take on what took place. It is, in my judgment, unnecessary to make detailed findings about this or about the rights and wrongs of what went on at this time. It is enough to say the following, which is in the papers before me and either common ground or clear. And subparagraph 1 refers to that conversation. And it's perhaps important to point out that he doesn't assume against the defendant that Mr. Markle had lied when denying in this conversation that took place that he had colluded with the paparazzi. He simply refers to the fact that her father had apologised. That apology is absolutely clear in the text messages, his willingness to apologise. And in respect of the numerous calls, again, he refers to the text from the claimant's husband. This is subparagraph 8. Stop talking to the press for your sake and hers. Prince Harry expressed concern that, as he said, Mr. Markle hadn't returned any of our 20-plus calls since we all spoke on Saturday morning. A grieved message was sent from Mr. Markle's phone in response, which said he knew nothing about receiving 20 phone calls, suggested that he'd been ignored. I don't need to quote the following text. The messages did not address the request to stop speaking to the press. Under 41, all of the correspondence to which I have referred, including the telephone call, was personal and private in character. There's no basis on which to suppose that any of it was created, crafted, or curated by the claimant or Prince Harry for the purposes of public consumption. The defendant makes no such suggestion. So, in fairness to the judge, and indeed to all parties, he recites the material events in his view without finding it necessary to reach a conclusion on the facts. It can hardly be said to be unfair to the defendant, absent some cogent and logical reason for thinking that any of what transpired in the week leading up to the wedding provided a justification for deploying the extracts of the letter. So again, we always come back to this question of what the contents of the letter were. And they were all, putting it bluntly, they were all one-sided. Hardly surprising, since the letter came from the claimant. As it happens, I think there were 7 or 8 references in the texts to the claimant or her husband saying, please pick up the phone, we're trying to call you, please pick up the phone. Then there's the reference to the 20 plus phone calls towards the end of that week. We actually didn't understand it to be disputed that they were a correct reflection of what had happened, but if it isn't going to be accepted, we say it doesn't matter because it cannot bear upon the justification for the disclosures of the letter. Could I move on to the complaint about AAA? Which I think I can deal with relatively shortly. The way it's put is that the judge failed to have regard to the conduct of the claimant prior, or sufficient regard to the conduct of the claimant prior to the publication of the articles, and indeed, I think it's said beyond the publication of the articles, and relies upon the AAA case as saying that if a claimant is ambivalent about the protection of her private information, displays sufficient ambivalence about it, then that may be a factor which I don't think it's now said extinguishes, maybe it is. In AAA it didn't extinguish, it merely diminished the reasonable expectation of privacy which the judge in that case found to exist in respect to the information. The AAA case is a perfect example of a case which is not helpful to the facts of this case. An important distinction is, or I should say, the inquiry must focus on what is it that the claimant is alleged to be ambivalent about. In AAA, we were talking of, the court was dealing with a single item of information, namely relating to the paternity of the claimant's child, which was either out in the public domain or not. It qualitatively didn't have the same dimensions or nuances, self-evidently, of the contents of a private letter. So one needs to approach AAA with care. And the real question is whether or not anything that the defendant pointed to by way of alleged conduct on the part of the claimant demonstrated, or arguably demonstrated, sufficient ambivalence, to use that word, with regard to the contents of her letter. That's the question. And the answer to that, we say, as the judge rightly found, was no. The devil, again, is in the detail, and the defendant's case at its highest went no higher than the 25-word summary of the letter, which appeared in People magazine, which the defendant describes as a description of the contents of the letter. We wouldn't accept that as a fair characterization of what it was. It was a brief passing reference to a very, very long letter. But the key question is, did she arguably display sufficient ambivalence to the contents of the letter? And even assuming that she had authorised friend C, I should say the long-time friend, who's quoted in People, even assuming she had authorised the long-time friend to provide that information in relation to the letter, it couldn't possibly justify the deployment of the extensive extracts. There's simply an unbridgeable gap between that 25-word reference and the contents of the letter. It does raise this question of control when one looks at what's alleged to have happened after the publication of the articles, because of course the defendant relies on the book. We say, and the judge also said, in effect, that she could have provided the letter to the authors for publication. Perhaps all of it. And that wouldn't undermine or prevent the claimant from asserting her rights in respect of the letter. He's right about that. Because any other answer leads to the proposition that the editor of a newspaper has the right to decide when to first publish a private letter, not the writer of the letter. We say that is not the law of this country. It would also invite questions about at what point does the writer of the letter lose their right of privacy. On the facts of this case, the disclosure, not of the letter but information about it, is alleged to have happened before the defendant published its articles, but the book doesn't come out until a year and a half later. Now, assuming that, which again is not even pleaded, that knowing that the book was in preparation, she had given a copy to the authors with permission to publish it, is it said that the minute she makes that decision, that gives the editor of the newspaper the right to step in and say, aha, you're intending to publish this letter, so we can get in and do it first? Obviously cannot be right. Again, one goes back to Campbell and Roddy. It's for the claimant to decide when, to whom, how much of, and how to share her private information. And that is why, on analysis, the only relevance, the book disclosure, if I can put it that way, cannot add anything to the People disclosure, because the only relevance of the People disclosure is, as pleaded, that it constituted an attack upon Mr. Markle that he was entitled to correct. Self-evidently, anything that came out in the book came out a year and a half after the defendant's own articles. So it couldn't possibly serve as any sort of public interest justification for the disclosure, the publication of the extensive extracts from the letter, occurring so long after the event as it did. So not only does it not add anything to the people disclosure, bearing in mind that they are said to be the same information is alleged to have been provided to the authors, but it's actually a lesser case. It doesn't work because such attack as the book contained on Mr. Markle was published a year and a half after the articles. Now, as it happens, we say that factually the case on the book was hopeless anyway, because all Mr. Scovey did, and he puts this in his witness statement, is lift a very small part of the extracts from the letter that the defendant itself had published. That was an issue which the judge rightly expressed scepticism about the defendant's case on, but he was prepared to assume in favour of the defendant that the authors of the book were provided with the same information as appeared in People. Could I just briefly deal with it's described by my learned friend as fresh evidence. Actually, what's before the court is two witness statements, but also the text messages provided after the witness statement of Mr. Nauf, and a complete set, I say complete set, subject to disqualification, the emails that Mr. Nauf discovered dealing with his contacts with the authors were in fact less than those that the claimant was able to locate when doing her own email searches after provision of Mr. Nauf's witness statement, albeit there wasn't much in terms of emails. Before I do so, just in context, a document which the court wasn't taken to, but which is the important background event to the writing of the letter, is the article of 28th of July, which was published in the Mail Online, supplementary bundle, page 308. This is an article which is referred to by the judge in his summary of events. Paragraph 42.2, which I don't ask you to go to, but it's a long article, headline, perhaps it'd be easier if I was dead. Heartbroken Thomas Markle says his daughter is ignoring him and has changed all her numbers since marrying Harry, but he won't let the palace silence him. At the bottom of the page, Thomas Markle today claims in the Mail on Sunday that Meghan has cruelly excised him from her life and he fears he may never see any children she and Harry may have. Over the page at 309, I'm not going to read all this, but just a few bits that are relevant. Retired award-winning Hollywood lighting director Mr. Markle hasn't spoken to his beloved Bean, his childhood nickname for Meghan, for more than 10 weeks, and claims the rift is punishment for him staging fake paparazzi pictures before the wedding and then daring to speak out in his own defence. I'm really hurt that she's cut me off completely. I used to have a phone number. They cut me off. Those numbers were disconnected. They no longer work. I have no way of contacting my daughter, he says. Just for the avoidance of doubt, that is disputed as a matter of fact between the parties, but it doesn't matter for present purposes. 311, staging fake paparazzi pictures. This is the second last paragraph, including one of being measured for a wedding suit at a shop in Rosarito that actually sold party supplies, was a huge mistake, he admits. In an interview with MOS columnist Piers Morgan, he apologised for the fake pictures but broke protocol by revealing Prince Harry's political views. If you then move on to the third paragraph, how tragic is that to deprive a child of its grandfather because I said a few things critical of the royal family? And then there's some rather unpleasant remarks attributed to him, which I think I only need to ask you to read down to the middle of that page, as if there's a special way to apologise to the royal family. Then over the page at 313, he's angry that Meghan has talked about support her yoga-loving mother Doria has given her, but gives him no credit. There's a few paragraphs on that topic. And then in a large sub-headline in 314, there's a reference to Princess Diana, which I won't read. Thomas Markle hits out at Palace for taking strained Meghan away from him and admits he doesn't care if Prince Harry ever speaks to him again. That interview, which was said to be based on a 9-hour interview between Mr. Markle and the Mail Online, which he has disputed, I think, some of the things that are attributed to him, if anything, could be described as an attack, a public attack, both on the claimant and on the family into which she had married. It would be this letter. And this was, in causal terms, this was a very important part, a triggering event, that led to the writing of the letter. The difference between her father and the claimant in this respect was that the attack is made publicly. It's self-evidently of a kind likely to cause difficulty in her relationship with her family. And she touches upon this in the witness statement. The claimant's response is to write privately to her father. So the language of reply to attack that the learned friend used yesterday struck us as slightly ironic, given the important background to the writing of the letter. And there's always a danger with replies to attack that one actually has to look at where the attack, who made the first attack. But with that in mind, I then need to take you briefly to the claimant's pleaded answer in response to the defendant's case that it was allowed to put on the record in September of last year, to the case that the defendant was then making. It has now abandoned nearly all of it, but the case that the defendant was then making about the genesis and creation of the letter. And in essential summary, the pleaded case against her was that she had written it with a view to publication, or for the public record, as it was put in the grounds of appeal, that she had considered it as part of a media strategy to improve or enhance her image, that she intended it to reach the public domain or thought it was likely. And that she knew or suspected that if Mr. Markle leaked it, sorry, that if it was put into the public domain, Mr. Markle was bound to disclose it. Nearly all of that has now gone from the defence, but what matters for present purposes is the case that she pleaded back in November of last year. This is at tab 26, a bundle, core bundle, paragraph 12.7a,
Page
609 to 611. If I could just ask the court to read from the beginning of 12.7a down to the end of subparagraph 5, the bottom of 610.
So you have to give me those paragraphs again.
Yes, my lord, starting on 609 towards the bottom of the page, the main paragraph 12.7a, and down through 1 to 5, subparagraphs 1 to 5 under 12.7a. You'll have noted the reference in 1 to the escalation of the claimant's father's tabloid media interviews and the narrative which then follows about the receiving of advice and her decision to write a letter to her father and her the assistance she got from her trusted advisor, Mr. Nauf, who was the head of Kensington Palace Communications. And at 5, the fairly detailed account of the process of writing it, which was a painful process, she says, a deeply painful process, that Mr. Nauf lived through with her. And you'll have seen the reference to him providing feedback. At subparagraph 6, there is the conclusory paragraph, the summary of a rebuttal of the defendant's case. As is clear from the above, the genesis of reasons for and intended use of the letter was the complete opposite of the media strategy. It was a private letter written and sent by the claimant to her father on the advice of senior members of the royal family in an attempt to protect her family, including her new family members, from further media intrusion and embarrassment to the institution. The defendant's contentions to the contrary, which are wholly speculative and unsubstantiated by any evidence, are deeply offensive. I don't think I need to read on. Now, my lord, with that pleaded case in mind, will the court please bear in mind that this case was pleaded in November of last year without my client having the benefit of sight of the contemporaneous text messages between Mr. Nauf and the claimant, which have come to light subsequent to Mr. Nauf's witness statement. What is striking about those text messages, when fairly analysed, rather than cherry-picked as my own friend did yesterday, what is striking is how accurately her account in this part of her amended reply reflects the truth as it appears from the contemporaneous messages. The only thing which she appears to have got wrong was that the feedback that Mr. Nauf provided, as referred to in subparagraph 5, didn't occur in the course of a discussion, but it was actually provided by text message itself.
Why does any of this matter?
Well, it's first of all, it's important for the court to realise how much has now gone from the defendant's case.
It may be, but as I understand it, your case doesn't depend on the defendant having a lesser case than it had before the judge. You say the judge was right on their greater case before the judge, and presumably by extension, if you're right, he was right about the lesser case.
Yes.
I mean, I can't understand why we're getting into all this stuff, if I can put it this way, about who said that one person said the other person said something else. I just don't see that it can affect a right to summary judgment. Either you're right, that there is no reasonably arguable defence on the defendant's pleaded case. The defendant can strike out bits of the pleaded case or put in more things it wants us to ask us to look at. But it doesn't seem to me at the moment that any of the more things they put in add up to a row of beans beyond what was there before.
Well,
Why do we have to get into an agonising treatment of the text messages that may or may not have taken place, or did take place, unless they add further to the defendant's case, which is not said?
Well, Lord, it's that last bit that was the reason I do it defensively, because it's the defendant's position that somehow their case is strengthened by the new evidence. We say it's actually the opposite.
And he assumed in their favour.
Exactly. The judge assumed in their favour that what we say is the higher case would be made out. The defendant says, oh, well, look at what these texts say. We say, well, actually, they show that she's actually regarding the letter as confidential. She doesn't even allow her private secretary to be shown a draft. So the putting it shortly, my lord, and I say this responsibly to the defendant, there is no real prospect that the evidence that the defendant now relies on could show anything higher than a case that she regarded as a possibility.
Do you say we should admit the evidence?
No, because we say it's all about the characterisation of the evidence. It's only relevant if the defendant is going to suggest that somehow it transforms the case. We say it can't transform the case because all it shows is that
what the case?
It can't transform their case into something better than was before the judge, because all it shows is that she acknowledged the possibility that her father might leak it. It doesn't support, in fact, it undermines the case that she thought it was likely or wanted the letter disclosed. And as regards the twin point on this, as regards cooperation with the authors, and I can take this very shortly, is that when one actually looks at the only document which matters on dealings with the authors by Mr. Nauf, a great song and dance was made about this by Mr. Caldecott. But what really matters is the information that appears on page 74.18 of the applications bundle. And this is the background reminders to Mr. Nauf of material which, on her case, he knew anyway. This is the background reminders that she includes below just in case ahead of his meeting. What is, again, striking and wholly inconsistent with the defendant's pleaded case below and its new pleaded case, which I trust your lordships are not going to be, ladyship will not be troubled with, is how little information about her father she was prepared to contemplate Mr. Nauf giving to the authors. And even more than that, absolutely no reference to the letter. Not even the fact of it. She's simply not prepared to go there. This is halfway down the page of 74.19, under the author's topic bullet point, family relationship with family and father, past and present. Every single aspect of those 4 bullet points that were provided were, on any view, anodyne, on her case, already in the public domain anyway, and most important of all, say absolutely nothing about the letter. Which is why we say the entire case about her cooperation with the authors simply falls flat. And what your lordships and my lady don't know is that there was a whole series of convoluted allegations in the defence which have now been abandoned, to the effect that she was getting frustrated with her communications team and she therefore decided to bypass them and use her friends as a conduit, that the publication date was put back, so her friends decide to act sooner to put stuff into the public domain, and that's what leads to the people. There's a whole load of factual premises to this convoluted case which have now disappeared. They don't even maintain the allegation that she and her husband cooperated with the authors to put out what they called as, they referred to as their version of the events. That's gone. So what one is left with is a proposition that on its face makes no sense. That whilst on the one hand she is quite openly, as far as Mr. Nauf is concerned, allowing him, as part of the job that he does, this is what he's paid to do, is to deal with media inquiries. She's quite happy to provide him with some background information for his meeting with the authors. But it doesn't include the letter. And she had every opportunity. This was the perfect opportunity if she wanted to put it into the public domain.
Well, I mean, paragraph 7 of the judge's judgment assumes in the defendant's favour that she intended the letter to be publicised, to that end disclosed information about it to the best friends quoted in the People article, for the purposes of their biography, which is much higher.
It is. Well, my lord,
I just don't see
I respectfully agree. It's, as I say, it's defensive against this suggestion that somehow their case is improved on the evidence.
We have to try and keep this case within some kind of bounds. I mean, this is an appeal against a summary judgment. I mean, that's a very binary case. They have to show there was a tribal issue the judge failed to recognise on the facts, which he ought to have led to his sending the case to trial or some other reason for a trial. Getting into the facts and determining it by way of mini-trial or otherwise is precisely what we are not able to do.
Yes, well, Lord, I don't need to say any more other than that, first of all, to answer, in fairness to my client, the song and dance that Mr. Caldecott made about it yesterday.
I mean, to be fair to Mr. Caldecott, I don't really remember a song and dance about all this, but anyway, there we are.
Well, I think that the complaint is that somehow disclosure would transform the case. It's a sort of McCawberite submission.
Well, that is a possible argument that disclosure may change, but the point about disclosure is if the parameters of the case do not admit of anything but success for the claimant, you can have as much disclosure as you like, but it won't affect the parameters of the case in the claimant's favour. If not, not.
Yes, well, I respectfully, wholeheartedly agree, and disclosure only matters if it goes to an issue which the judge didn't accept in favour of the defendant.
I mean, I have no doubt, if it's any help to you, that the facts of this long relationship are likely to be highly complex and very unknown at this stage, quite obviously.
Well, no, the short point is that the judge took the defendant's case at its highest.
That's the short point.
That's the short point. and nothing that the learned friend that took you to can change that.
I mean, what he's got to get is, as I always call it, his screwdriver into the judge's judgment to show that the critical paragraphs, which are really in the 120s, were wrong. He hasn't suggested that law was wrong, apart from the question on justification versus necessity, but he has to show that the approach the judge took to the rebuttal, effectively, of the People article was wrong. And if it was, you lose, Mr. Rushbrook. But you've dealt with all that.
And it's all on the premise that the defendant's case was taken at its highest in relation to the pleaded case. Lord, I think I've covered all the points that I wanted to. I'm conscious that the goalposts have slightly moved in terms of the complaints about errors of law. Mr. Caldecott helpfully provided to us yesterday a 1.5 page list of alleged errors. If I've missed any, might I put in a short written rebuttal of the complaint?
I mean, I'd much rather you didn't.
Well, I don't think I have, but
I would take instructions, whilst I imagine Mr. Mill will be addressing us very briefly on the subject of copyright.
well, I'm content to deal with it on that basis. The only thing I think I need just to clarify is that the respondent's notice, which no attention has been paid to, doesn't need any attention, because nearly all of the pleaded contentions that we were saying the judge actually should have held had no real prospect of success. Nearly all of those have now gone from the defence, and I think, being realistic, the outcome of this appeal is not going to turn upon the question of whether what's left, having regard to the new draft re-amended defence, is viable or not. I mean, that's not really what matters in this appeal. So I don't think I need to say anything more about this.
I mean, the new draft re-amended, whatever, amended defence seems to me to have no status before this court. Very interesting, I'm sure, and if we had endless time, no doubt we'd read it very carefully. But as it seems to me, it's not put front and centre of Mr. Caldecott's argument.
Well, and on that basis, beyond noting that nearly all of those contentions have gone from the defence in the respondent's notice, I don't propose to say anything more about it. So, any further questions I can assist you with?
Thank you very much, Mr. Rushbrook. Yes, Mr. Bell.
Lords, my lady, I fully intend to adopt the invitation from the learned Master of the Rolls to be brief. I do so for two reasons. Firstly, because that is the way I tend to do my advocacy. And secondly, because there isn't really a great deal to be said, that needs to be said, in response to the summary judgment on the copyright issues. I have it under 6 topics. I won't even tell you what the 6 topics are. I will just address them in turn. The first is headed the copyright in the electronic draft. My lords, my lady, the defendant seeks to distort the character and content of that draft. It does so in order to suggest that the use of its content was not a weighty matter when balancing conflicting rights. The submissions made by my learned friend Mr. Speck are wrong in 3 material respects. Firstly, it is quite wrong simply to characterise the electronic draft and the letter as being a short factual narrative. My Lord, the Master of the Rolls himself referred to it as a carefully crafted document, and there are a number of passages in the learned judge's judgment where he quite rightly describes the letter in terms which go way beyond a factual narrative. The court has, of course, read the draft and the letter carefully, and I don't need to draw attention two passages in it specifically to make this point. But can I just give you the paragraphs in the learned judge's judgment where he addresses it? They are in paragraph 73, in paragraph 76.1, 76.2, and then in conclusory fashion, which I will return to, 148. The court was also referred just now by my learned friend to passages in the re-amended reply of my client, which make it clear that the work that was done over a considerable period of time. The particular reference in that document is paragraph 12.7a.5. The second point is that my learned friend suggests that in some way, because there is factual content contained within the document, that is relevant by way of diminishing the value and the weight of the copyright. And he suggests that because all that is left in terms of intellectual creativity is the choice of words used. When those responsible for granting Sir Winston Churchill the Nobel Prize in Literature because of his mastery of historical and biographical description, they were recognizing that which is fairly obvious, which is that the extent and the value and the weight of the copyright depends on the mode of expression just as much as anything else, and is perfectly capable of being substantial and weighty. I'm not suggesting that the electronic draft and the letter are Shakespearean in their quality, but nonetheless they show some considerable effort, but beyond effort, use of colourful and specific language meticulously put together. There is no reason not to give that full weight. And to the extent that one always listens with care to Mr. Speck when he seeks to educate the court on the law of copyright, one observes that even Homer can nod, and on this occasion, in relation to this point, he most certainly has. The third point is a point which I do invite the court's attention to, in particular. Where you have a factual piece of writing, that is to say, a piece of writing which takes on board events which have occurred, the property right, it is submitted, is particularly weighty when set against an Article 10 right. Because in the normal way, the person who is reproducing the contents can reproduce the underlying factual material and thus uphold the Article 10 right without encroaching on the property right. Is that a point which the court understands? I hope so, but it is an important point. I'll come back to it and illustrate it in the context of my submission on the balancing exercise in due course, but I do at this stage commend that point to the court. Second heading is the alleged failure of the judge to assess the weight to attach to the copyright and its infringement for the purposes of the defences with which this appeal is concerned. That is simply wrong. And can I illustrate that in the following way? Firstly, and to do so by reference to the judgment, which is probably a useful starting place to go. And paragraph 139. Under the heading of originalities, page 159 in the bundle, the learned judge said, "This is by common sense a key issue. In principle, the questions of whether and to what extent a work is original are relevant to the subsistence of copyright and to issues of infringement. Whether more than one person takes part in the creation, the degree of originality of different parts may have a bearing on the question of ownership." Again, the nature and degree of the originality involved in the work can affect the availability of defences such as fair dealing, public interest, and if this is separate, freedom of expression. So the starting point is that the learned judge fully recognised the issue, which it is said he ignored. And that is not, given that he expressly set it out in paragraph 139 of his judgment shortly before he dealt with those very issues of defences, is not a very promising starting point for the submission that my learned friend made. And when, my lords, in paragraph 148, he concluded that paragraph in the way that I will read out now, he's then talking about the contents of the electronic draft in the letter. He says they are much more than a short and banal insult. They comprise a long-form telling of, selecting a variety of literary forms interwoven with the narrative I've just discussed. The document expresses the exercise of expressive choice. The fact that the literary form was novel and interesting with a personal stamp appears to be reflected in the way the defendant chose to deploy it so extensively. That, if I may respectfully say so, is precisely what he was doing and which he is criticised for not doing, which is assessing the weight to be given to the copyright. And what he then goes on to say at paragraph 155, under the heading of fair dealing, halfway down, is the defendant copied a large and important proportion of the work's original literary content. The use involved an infringement of the claimant's privacy rights and was, with the modest exception I've identified, irrelevant to any legitimate reporting purpose and disproportionate. So what he has done with respect is completely unimpeachable. He's established the issue, he's considered the weight attached to the copyright, and then he's determined the extent to which it's been infringed. And that is precisely what he was obliged to do, and it is what he has done. Third heading, Ries and Ashdown. The learned judge is criticised for not having referred to or relied upon the principles in Ries. Could you please turn to tab 14 in the bundle, core bundle 1. This is the learned judge's reasons for refusing permission to appeal to this court. And you will see at the bottom of 197 under the heading copyright infringement that my learned friend Mr. Speck made submissions to him focused on two particular submissions.
So which page is it?
I'm so sorry, my lord, 197?
Sorry. Yeah.
The second of those is that his approach to the Article 10 defence gave it too narrow a scope and treated competing rights as having greater weight, thereby contravening the principles in Ries. What he says about that over leaf at paragraph 8 is as follows. As for the principles in Ries established 17 years ago, I suspect I may have cited these more often than any other judge at first instance. They are so well embedded in the jurisprudence, it's hardly necessary to reiterate them. But I did so in this case, albeit via citation of my recent judgment in Sikri and the Court of Appeal decision in ZXC at 105. This ground appears to rest on a misplaced semantic analysis which cannot be sustained when what I said is read properly in context. In particular, the suggestions that I treated property rights as weightier than freedom of expression or treated the effect of Article 10 as substantially covered by the fair dealing defence are, in my view, untenable. For your Lordship's note, the reference that the learned judge makes there to his judgment referring to Sikri and to ZXC is to paragraph 29 of the judgment. So that's the first point. He had Ries well in mind. Secondly, my learned friend refers to Cartier and says, yes, well, Mr. Justice Arnold, on the facts of that case, referred to Ries, he didn't refer to Ashdown. So what? I don't know whether Ashdown was cited to the learned judge on the facts of that case, but those facts of that case were so completely different from this one. It was a completely one-sided case. There was nothing to weigh against the property right, because these were people who were infringing trademarks in a wholesale fashion, and they had no rights to be protected. But in any event, so what? I don't understand my learned friend to be saying that Ashdown is wrong or has been overturned. It's clearly a relevant case to look at in the context which deserves it, which this case did, as I will come on to show. The next point is to explain the context in which we rely upon Ashdown. We don't rely upon Ashdown, nor did we before the judge.
This is not your fourth heading. This is the.
This is all part of the
third
Res Ashdown,
Yes,
but this is 3 part 2.
the context.
The context in which we refer to Ashdown is for the general principles that are to be derived, not for a submission that, given the facts of this case and given the decision in Ashdown, the court was inevitably bound to find in our favour. Now, I'm going to come back to the principles later on under heading 5, but I just make that point at this point. I should, however, say one thing about the Maloney friend's attempt to distinguish Ashdown from this case. He says that it's a case that is to be distinguished because that case was all about authenticity. I wonder if we could look at the re-amended defence in this case, just to see how the issue arises here. And that is tab 21, so I think core bundle 2. And could you turn within that, please, to page 345. Actually, perhaps, probably to get it in its proper context, we could turn, I'm so sorry, to page 362 and 3. Paragraph 36, to which my friend took you, is the plea in relation to Mr. Markle's rights under Article 10. And there are particulars set out below that. And then 37 on the next page is the reference to fair dealing. And your lordships, my lady, will see that under 36.1 and under 37, there are reference to the identical paragraphs of the defence. Those include 15 to 1516. And if you go back to page 345, we see paragraph 1514, which is the way in which the defendant seeks to justify the use of the text of the letter as opposed to a descriptor of its content. The identification of the words complained of by the claimant in Appendix A to the response confirms that the claimant does not allege that it was unlawful for the defendant to publish an article referring to the fact that the claimant sent the letter to her father, that her father was upset by the contents of the letter, and that he had written a letter to the claimant in response from which quotes are set out. The parts of the article setting out these matters are not complained of. It was a matter of editorial discretion and judgment to illustrate such an admittedly lawful article with extracts from the letter to give the article conviction and to engage the attention of readers. Now, as I understand it, my lords, that taken together with Mr. Verity's witness statement, when they're talking about giving the article conviction, that's the authenticity point. The only other matter that they rely upon to justify the use of the text of the letter is to engage the attention of readers. And in that context, I do invite you to look at what was said by the Court of Appeal in Ashdown at, I believe, paragraph 82. So that's tab 15 in the First Authorities Bible. So paragraph 82, it says as follows: there may in law have been justification for the publication of the confidential information that was contained in the minute. That is not an issue which is before this court. We do not, however, consider it arguable there was any justification for the extent of the reproduction of Mr. Ashdown's own words. It appears to us that the minute was deliberately filleted in order to extract colourful passages that were most likely to add flavour to the article and thus to appeal to the readership of the newspaper. Mr. Ashdown's work was deployed in the way that it was for reasons that were essentially journalistic in furtherance of the commercial interests of the Telegraph Group. We do not consider it arguable that Article 10 requires the Telegraph Group should be able to profit from this use of Mr. Ashdown's copyright without paying compensation. And the reference there to journalistic considerations is effectively precisely what is said in 1514, where it said it was a matter of editorial discretion and judgment. So although I don't rely upon Ashdown as saying the facts of that case mean we have to mean on this case, nonetheless, it is to be noted that the Court of Appeal specifically deprecated the idea that it could be fair dealing to use the precise text essentially to generate money for the defendant, which is, to be clear, precisely what we say, and it appears they admit was done in this case. That's my third heading. My fourth heading is balance. Now, my lords, my lady, I listened with care to what the learned Master of the Rolls said yesterday to Mr. Speck. Effectively, well, if you win on the privacy case, then you're bound to win. I think your lordship said bound to win on ground 8 and probably ground 9 will follow as well. May I, with the greatest of respect, seek to persuade your lordship otherwise?
Of course.
Thank you. I'm much obliged. My lords, the basis upon which, as I understand it, it was being suggested that we could not win if we lost the privacy case is because it would follow that Mr. Justice Warby conducted the wrong balancing exercise because he, for example, didn't take into account all the matters that it was appropriate for Mr. Thomas Markle to respond to beyond the olive branch, par exemple. So be it. But what's that got to do with the text? This is the point that I was making at the outset about the weightier nature of the property right where you're dealing with factual piece of writing. It was totally open to Mr. Markle, to the Mail on Sunday, to describe the content of the letter to a greater extent than the learned judge said was appropriate, but without using the text. So with the greatest respect, the first point is it by no means follows that if we lose on the privacy claim, we lose on the copyright claim. Quite the contrary, because unless your lordships can conclude that it must follow that Mr. Markle and the defendant were entitled to use the text to a greater extent than Mr. Justice Warby said was permissible, then nothing else follows from it. That's the first point. The second point is this. Why have a trial, even if your lordships are right, and my lady is right on that? What? I hear all the suggestion of this being a triable issue and having to go to... What facts? What facts? I have not heard a single fact, triable fact, on the other side, would need to be taken to trial or need to be established at a trial in order for that evaluation, that rebalancing exercise to be carried out. And your lordships are, with the greatest respect, required by the jurisprudence on summary judgment applications such as this to determine issues. And let's look at the language. It's in the learned judge's judgment at the outset. This is a quotation from Easier.
Sure we need it except for forensic flourish, Mr. Mayor.
I'm sorry, my lord.
I think we need easy air except for forensic flourish. You're saying you should grasp the nettle if there is no reason not to.
Yes, there's no not to, and there's no reason not to unless you are prepared to accept that there is material which may come out which is germane to the outcome of the case at a trial. So you're right, I don't need to take it there, but your lordship, I hope, has the submission.
I mean, when you said that I had said to Mr. Speck that if he won the privacy case, he'd win the copyright case, I might have said to you that if you won the privacy case, you'd probably win the copyright case for precisely the same reasons.
And I would have said, your lordship is wrong about that, but I win it for the reasons that I say. We win the copyright case, not for your lordship's reasons.
Well, for the reasons the judge gave.
For the reasons the judge gave, because he was clearly correct.
Yeah.
For the reasons that I hope I'm helpfully giving to the court
Yes.
this morning.
Fifth point.
My Lord, yes. Actually, I just wanted to say one other thing on that point about the use of the text. Mr. Markle, it was, who said that he wanted to be able to comment on the tone and content of the letter. It's referred to by the learned judge in paragraph 52 as judgment. And that expression, tone and content, is one that was all over my learned friend's submissions to you, both from Mr. Caldecott and in particular from Mr. Speck. And it is that which can be the only basis upon which they say it is appropriate to be able to refer to the text. You can describe the tone and the content of the letter without the need to show the text. So when your lordships, if your lordships are driven to it, decide that they have to carry out a fresh evaluation, the court will, with respect, I hope, take into account the points I have made, together with the fact that this letter was unpublished. My learned friend Mr. Speck just said, oh, well, there is that factor, it's unpublished. As is quite clear from the passage in Laddie, which everyone has accepted, sets out the position correctly. That is a hugely significant matter. And what that passage in Laddie says, which is cited by the judge in his judgment, is that ordinarily that's going to be the end of the matter. How can the Article 10 right outweigh in those circumstances? Lords, Mr. Speck at one point, I think this follows under the same heading. Mr. Speck at one point suggested that sometimes, effectively, more may be less. In other words, the more you quote, the less, or the more fair or less unfair the dealing is. Well, that's jolly interesting as a proposition, but how does he apply that to the current case? As I understand it, he wishes to do that by reference to material that's not before the court, to do with draft amendments to the pleadings and new evidence. And having taken, I will take the approach that the court invites me to adopt, and therefore I'm not even going to respond to that. But what we've got here is an extraordinary amount of reproduction. Just to give you some idea of it, the judgment of paragraph 56.
Just over half, isn't it, Mr. Mill?
Well, Lord, it's actually just under half.
Just under half.
I'll give you the
About
reference
half.
for that, but can I just give you 56? The minimum number of repetitions was 1, and the maximum number was 12. Taken together, the articles contained 88 separate instances of quotation from the letter. And I think the 47%, your Lordship may have got that from our skeleton below, which is in the supplemental bundle at tab 16. And the page is 160. I think that's a false reference. Just bear with me a moment. I'm so sorry. It's 187. So paragraph 161, you will see how that 88 quotes is split up. 16 quotes in Article 1, 14 in Article 2, 17 in Article 3, 23 in Article 4, and no fewer than 18 in that ridiculous article about the handwriting. And what we say there is that Articles 1 and 2 contain different quotes numbering 15 and 14 respectively in total. Articles 3 and 4 and 5 repeat the quotes from Articles 1 and 2. A total of almost 50% of the content of the letter is reproduced at least once in the articles. And I should just also finally on that point, draw your attention to 150 in the judgment. Where it is said that the letter as a whole ran to 1,250 words, of which the male articles reproduce 585. And the approach taken below by the defendants in relation to the handwriting article, which as I understand it is still maintained here, is that the court shouldn't look at that independently. You should look at it cumulatively as part of the overall picture when deciding whether fair dealing has been undertaken. I will be corrected if that's no longer their position, but it was expressly in writing before the learned judge below. Well, so be it. In that case, I'm entitled to rely upon the handwriting article as being the clearest possible indication that overall this was not fair dealing or one where the balance is in favour of the defendant, because there cannot be any sensible explanation for that consistent with the enforcement of an Article 10 right or fair dealing with the article. That's 4. The next is the judge's reason for rejecting Article 10. So, what Mr. Speck said in his submissions to you yesterday is that the judge is wrong in saying that the grounds relied upon for free speech and fair dealing are not materially different. Of course, it's true that the underlying factual narrative, the specific paragraphs referred to earlier in the pleading, the actual grounds differ significantly, not least Thomas Markle's reliance on his free speech rights. So I think it's relevant in that context, first of all, to look to see what the learned judge said, and then to look at the pleading. So the learned judge, in deciding the Article 10 aspect of the case, referred to Ashdown, and I'll come back to Ashdown in a moment if I may, in 157. And then in 158 he said, in my judgment, this is not one of the rare cases referred to in Ashdown. There is no basis on which the court could conclude that although the copying of the work was not owed fair dealing for news reporting purposes, the public interest requires the copyright to be overridden. That's his conclusion. Then what he says is the reasons for that conclusion, are sufficiently explained by what I've said already, because the grounds relied upon to justify the public interest argument are not materially different from those advanced in support of the fair dealing defence. And what my learned friend said to you yesterday is, well, if you look at the pleading in relation to fair dealing and freedom of expression, then they are materially different. Well, we don't accept that. So I need to take you to the relevant parts of the defence in order to make my submission good on that. So it's page 362 in Core Bundle 2. Paragraph 36 deals with the Article 10 claim. As I've indicated, the paragraphs that are relied upon in 36.1 are identical to those relied upon in 37. What my learned friend points to is paragraph 36.2 as being entirely separate from what's under paragraph 37. And your lordships and my lady can read paragraph 36.2 to themselves. But if you then go and read that and set that against what's in 37, below the passage which deals with the paragraphs that are relied upon, It is essentially the same point, albeit expressed in a slightly different way. The claimant's relationship with, estrangement from, and her conduct towards her father were accordingly all particularly current and placed in or raised in profile in the news agenda by the claimant's own actions. Yet further, Mr. Markle's reaction to and view of the letter and the People interview were current events the legitimate subject of news reporting. In particular, his dispute with the version put in the public domain by the claimant's own actions and contradiction of and dispute with the version of the claimant's conduct towards him was also a current event, the legitimate subject of news reporting. So it may not be expressed in quite the same way, but the substance of it is the same. In any event, my lords, it's quite clear why the learned judge refused to allow the Article 10 defence. He did it for the reasons that he'd given in relation to fair dealing. And that was because, self-evidently, the use that was made was excessive and not fair, and when viewed in the light of his conclusion earlier on, that the only passage that it was permissible for the letter to, the only passage in the letter that it was permissible for the Mail to publish was what he terms his paragraph 15. It's quite obvious why he would have reached the conclusions that he did. In any event, finally, my lords,
which of course is the same reasons as the privacy claim is rejected.
Indeed, I accept that, but not the consequence that your lordship is inviting me to accept flows from it.
Of course not. We all have to have a reason for being here.
So true. My lord, I was then just going to draw attention to what Ashdown says, but your lordship has been taken to Ashdown. Can I just remind you of the paragraphs which set out points of general principle?
Yeah.
For your lordship's note, ladies' note, paragraphs 31, 39 to 45, and 66. And could you particularly note in 45, the way in which it's put in that paragraph is entirely consistent with Ries. Finally, and I note the time, and I can do this in 1 minute, pro sebum. It's the last point that was made by Mr. Speck after the luncheon adjournment yesterday. And as I understand his point on pro sebum, it's that the learned judge, contrary to the approach in pro sebum, allied together the question of purpose and fairness. Well, it's self-evident from the judgment that he didn't. If you look at paragraph 156, he said in 2 sentences at the bottom of that page, it was essentially for the purpose of reporting the contents of the letter, which was not a current event, and the use made was not fair. I mean, how clear does the learned judge need to be? He clearly wasn't eliding it. He was making 2 points. The point that my learned friend is really making, which gets him nowhere, is that the judge was wrong in his approach to what purpose meant for the purpose of that part of the exercise. The reason why he didn't put it that way is because, of course, that gets him nowhere on this appeal unless he can establish that the judge was also wrong in saying that the use made was not fair. So, my lords, I have, I hope, been brief. I would obviously be happy to answer questions, but subject to that and anything from my learned junior behind me, those are my submissions.
Well, you've been commendably brief, Mr. Mill, and we're grateful for that. Thank you. Well, I think we'll break now. I'm afraid to say that the lady and I have another engagement over lunchtime, which will detain us until, I guess, 2:10. So I'm going to say not before 2:05, just in case we manage to get back at breakneck speed. Unfortunately, it involves changing into more exotic robes, and that takes a little time. At 2:05. Yes, Mr. Caldecott, we've received an application from the Times newspaper for some more materials. We're inclined to deal with that at the end of the hearing rather than interrupting the hearing now.
Thank you.
Can you remind me if
I will, Lord, yes. Whatever phrase one uses, cut to the chase or elephant in the room, is plainly a pivotal submission which is interesting the court. And that submission, as I apprehend it, is this: the notion that republishing the accusations in the letter doesn't rebut anything save for the olive branch which the judge accepted. Because it's plainly a matter of interest to the court, I propose to take that first. But before I do so, can I just do a little scene setting, just reminding the court about the three public interests engaged. The first is the corrective public interest. The reasons I come to will say this case goes well beyond that. There is plainly a corrective public interest. Now, for those purposes, it's important just to quickly look at the code, if we could, not least because the court is obliged to have regard to the code on these issues. What is Bundle 2, Authorities Bundle 2 at tab 40. A learned friend took you briefly to it, but it actually pays slightly closer scrutiny. As the court will be aware, some of these headings have asterisks, and those are the asterisked ones are the ones which engage the public interest box at the bottom right-hand corner. And unsurprisingly, privacy is one of them. And privacy is point number 2, coming straight after accuracy, perhaps reflecting it's a very common problem which the media have to confront. The wording of 2.1 is broadly echoes the terms of Article 8. Roman 2, editors will be expected to justify intrusions into any individual's private life without consent. And then this sentence, which needs to be looked at carefully, in considering an individual's reasonable expectation of privacy, account will be taken of the complainant's own public disclosures of information, and then a quite distinct subparagraph about the material complained of, and the extent to which the material complained about is already in the public domain or will become so. Now, we submit that the phrase public disclosures of information is plainly dealing with something wider than the mere material complained of, where it otherwise the same wording would be used throughout. Now, the public interest exception appears in the bottom right-hand corner. There may be exceptions to the clauses marked asterisk where they can be demonstrated to be in the public interest. The public interest includes, but is not confined to, and indeed there are public interest issues here which don't easily fit within this list, but a very important one, and it's common ground, I think, between the parties, is at Roman 3, protecting the public from being misled by an action or statement of an individual or organisation. Can I just remind the court of 2, there is a public interest in freedom of expression itself. And as the court will know, Article 10 is always engaged. Article 8 is not. Article 10 is always engaged. Then at 4, editors invoking the public interest will need to demonstrate that they reasonably believed publication or journalistic activity taken with a view to publication would both serve and be proportionate to the public interest and explain how they reached that decision at the time, which of course is what Mr. Verity sought to do in his witness statement. Can I just for a purely historical observation, and we needn't go to it, the code as it was before Lady Hale in Campbell had no reference at all to having regard to public disclosures of information by the complainant. I'll just give the court, if I may, the reference where you'll see that. It's Authorities Bundle 1, tab 18, at page 393. So that's the first corrective public interest, and it's plainly one which is interesting the court, and I'll have to come back to it.
Could you remind me, Mr. Caldecott, where the reference is to the code in the judgment? Which paragraph it is?
But I have to. 159.
Thank you very much.
Well, and 32.
And 32, yes, I remember it's in 32 very early on, straight after 31, which is the one. 32.
Did you say the code in Campbell had no reference to the material complained about?
No, had no reference to disclosures, material disclosures of information by the complainant. That wider passage doesn't appear. I'm happy to show it to your lordship.
No, that's all right. That's all I need. Thank you.
Now, the second, quite different public interest, because it's, in a sense, a public interest exercised by an individual citizen who is under attack. And if he's been publicly attacked, his only recourse is to find a media entity to carry his reply. It's a completely different public interest, but a very important one. Now there I am prepared to accept for present purposes the learned friend's catch-all of fairly relevant. But if I just may remind my Lord the Master of the Rolls, who said that our only complaint about the law was really the necessary burden point, we do take issue quite importantly with the way the judge characterises this legal duty at points 6 and 7 of our note.
Sorry, this legal duty.
No, it's not. It's not a legal duty. It's an interest. The public have an interest once the attack is made in hearing the victim's reply.
Yes.
And the test for the reply is whether it's fairly relevant. I'm using my learned friend's phrase so we can try to reduce the amount in dispute.
Well, I mean, you say in 6 and 7, the judge was wrong to hold that a person is not entitled to reply to an attack if he or she merely believes
Yes.
his portrayal is untrue. But that doesn't perhaps address the point that is made against you. And then you say the parameters of Mr. Markle's entitlement to make a reply to the attack are much too narrowly stated
Yes.
by the judge.
Yes.
So what should the judge have said at 114 to 120? You know, we need to know what you say was wrong. And I have no note of your having referred to 114 and 115 in your opening submission.
Well, can I come back to this when I explain how we say this works on the facts? Because
Well, I do. I mean, you can.
Yes.
Of course, you can, Mr. Caldecott.
Well,
but I'm struggling with your appeal because it's you know, even the 12 paragraphs of this note, which I can tell you I have studied and re-studied, seem to me, if I may be bold, rather diffuse. If you're saying that there was a triable issue, I need to have it shortly stated. What
Yes.
was it?
Yes.
There should have been, judge should have sent for trial before he was justified in deciding the case. If you're saying the judge made an error of law, it's no good, if I may respectfully say so, saying it was too narrowly stated. I need to know what the error was.
Yes. Okay. I'm defending myself, it doesn't matter. But I did go to Lord Atkinson and did say what our position was. And Lord, it is in tab 43 of
Yes.
Authorities Bundle 2, and I specifically stated that this was the correct proposition.
Sorry, Lord Atkinson at page 1.
In Adam and Ward at 1725, page 10, I'm sorry, Lord, page
Adam
10.
and Ward is not a case that applies to, it's a defamation case, isn't it? You say it's directly, the judge ought to have found this defamation case directly reading across to privacy.
Yes, Lord, I'll come to why I say that. In this particular context, he might have honestly and on reasonable grounds believed that what he wrote or said was true and necessary for the purpose of his vindication, though in fact it was not so. Now, this is, I quite accept, this is only looking on the Article 10 side, and I've accepted that in a privacy case, one has to look at the privacy side as well. But if Mr. Markle honestly and reasonably believed that what he wrote was true and necessary for the purposes of his vindication, that is highly material, we say, to the weight of the Article 10 right.
Well, what if it objectively is not?
Oh, well, that's the elephant in the room, which I have to come to on the facts. Well, absolutely. Now, I totally accept that's an issue because the court says, well, at least my friend says, that the letter doesn't rebut anything, and I need to deal with that. Of course.
As you pointed out right at the beginning, is the key point in the case.
Yes, well, absolutely. That's why I'm coming to it.
I mean, the fact that he honestly and reasonably, I mean, to be honest, what Mr. Markle honestly and reasonably believed is slightly overshadowed when you read this document by what your clients were writing. I mean, your clients used the letter as a vehicle for Mr. Markle's responses. And one can imagine how it happened. They said, we got the letter, now she said this, what do you say? And then they wrote it down and reported it. Now, that is not really the stuff of a response to the People article.
Well, that's the critical issue. We say it is, and I'll explain why in a minute. But look, can I just? I always knew this opening, setting the scene, might irritate the court, but it is.
You never get irritated,
No,
Mr. Corbett.
but Lord, it is important to
Abundant
appreciate these three different public interests because they are different, and I'm just setting the scene. It really
Okay.
is important
All right.
because they have different consequences.
So the first public interest
Is the corrective public interest, which reflects the code protecting the public from being misled.
yes.
The second public interest, and I entirely accept that if Mr. Markle was wrong in his reasonable belief, then he obviously fails.
The second public interest is
Is the right of reply, Mr.
Right of-
Markle's right of reply.
Mr. Markle's right of reply. Yes.
And the third, and much wider public interest, is in the continuing debate prompted by the People article. And the judge rightly acknowledges that in the paragraph we don't object to, paragraph 31 of his judgment. Now, I'm just taking this in stages, if I may, because it's important. Fundamental to all three of these public interests is firstly identifying the charges made or arguably made by the People article, both individually and in terms of their cumulative impact. Having identified the charges, both individually and cumulatively, you cannot assess or balance the competing Article 8(10) rights, bearing in mind Mr. Markle's Article 8 right is also engaged, without considering two critical factors. One, to what extent the charges can be shown to be false or misleading. And secondly, what, and I put in brackets, if anything, because my friend says nothing, what, if anything, the text and tone of the letter contribute either to the wide public debate or are germane to the right of reply or contribute to a correction, shorthand for protecting the public from being misled. Now, I have obviously been through the People article in some detail already. Can I just, because my learned friend quite frequently used the term passing reference and matters of that sort, but just have a look, just for completion on this, at Core Bundle 2, tab 21, page 403 to 4. This is a follow-up article online in People magazine, almost entirely focused on Mr. Markle. Now, can I formulate, if I may, what we say is, or arguably is, the sting of the People article, the charge that we are concerned with? And this is fundamental to why we say...
We won't get the sting of the People article by looking at the follow-up, will we?
Well, you have to look at both. You're quite right. You'll get this. This is very similar, but it doesn't include the lying. What? It's part of the, apparently it's part of the same thing, I'm told.
Well, it's on the same date. It's dated the 6th
Yes,
of February.
I think it actually is actually part of the same. Yeah.
Yes, the third one.
Lord, can I just formulate, because this is absolutely central,
Yes, please formulate.
what the sting is of the People article overall. In the teeth of his daughter being always dutiful and supporting him throughout with incredible generosity, first he cold-shouldered her at the wedding at the most important point, or one of the most important points of her life. Secondly, he's lied about saying she'd shut him out. And thirdly, he gave a cynical and self-interested response, ignoring her pleas for reconciliation in a loving letter.
Sorry, just say that last one again.
Sorry, Lord, her pleas for reconciliation in a loving letter.
And third, he ignored her pleas.
Yes. Sorry, Lord, yes, he gave a cynical and selfish response, ignoring her pleas for reconciliation in a loving letter.
Just say the whole thing again. He did what?
The third is he gave a cynical and self-interested response, ignoring her pleas for reconciliation in a loving letter.
Okay, That's rather more complex than you put it before, right?
Well, I made the submission before,
You made the submission in more general terms.
but it always struck me that it might be helpful to formulate a sting so the court
I
could
want to
see.
read it out back to you, I'm afraid. In the teeth of his daughter being always dutiful and supporting him with incredible generosity, he cold-shouldered her at the wedding, the most important moment or point of her life. He's lied about her shutting him out. And third, he gave a cynical and self-interested response, ignoring her pleas for reconciliation in a loving letter.
Yes.
Right.
Now,
Thank you.
sorry, Lord. Can I just explain? Now, this is a submission I made when I opened the appeal. There's, and I think my Lord Master Rose also mentioned this, there's a synergy between what is said about her and what is said against him.
Yes.
It's the more appalling, his behaviour, because of the exceptionally loyal and dutiful way that she has behaved to him. It's all of a piece, and what is said about her and what is said against him are an integral part of the attack. Now, what my learned friend seeks to do is to pick out the individual allegations, but to crucially exclude from them what is said about the claimant. Because the problem he has is this. The letter, the text of the letter and the tone of the letter show that it's not a loving letter, is not a generous letter. And when we come to the very first allegation about cold shouldering at the wedding, crucially, this allegation is demonstrably false. We say, and on any view we have an arguable case that it's false, that he cold-shouldered her in the run-up to the wedding. The point is this: if her letter to him includes a thoroughly nasty and untrue allegation, which we say this is, the very fact that she makes that false allegation in the letter runs contrary to the whole way she is portrayed in the People article, which aggravates the allegations against him very considerably, we say. Now, the court has my submissions that the judge doesn't grapple with the falsity of the pre-wedding charge at all, and that his selection of texts excludes the crucial ones that give the lie to it. Now, my learned friend, and I listened very carefully to his submissions, did not advance any argument, really, that with the exception of the paparazzi photographs, there was any truth in the pre-wedding charge of cold shouldering. The paparazzi is a complete diversion, and the court should ignore it. Mr. Markle apologised for it, and his apology was accepted. Now, what about the suggestion that he'd lied, and this is a serious charge, he'd lied in saying she'd shut him out. Now, that is something that the public are being told. To a degree, the truth of that is a triable issue, but she accepts herself that there was no contact between her and him at the wedding. And if we go to the letter, we can see that this allegation is floated. I've already taken the court to where the letter makes the wedding allegation. It does so in a number of places.
Sorry, can we look at it? Which page?
Well, it's convenient. Paragraph 45 of the judgment is probably the easiest place to look at the letter, because it has helpful numbered paragraphs.
Yes.
On the wedding allegation, I mentioned these before and went through the small words. It's the bit at the end of 1, 2, 4, 7. And on the cutting off allegation, 14 is material. You haven't reached out to me since the week of our wedding. While you claim no way of contacting me, my number has remained the same. Now, Mr. Markle, we know, says that too is untrue. I've sent numerous texts and I get no response. It's in the Mail article. This is, again, an issue which can't be tried now. So again, it's relevant to look at the letter to see really whether the daughter is treating her father dutifully, generously, or fairly. And lastly, and not insignificantly, the letter is presented in the People article as a loving letter. What is the best evidence to refute that but the tone and text of the letter? We pleaded that it was necessary, not because that is a legal test, but because it was necessary to put the public right about these matters. This is all at the moment I'm looking purely under the corrective, which is in one sense the most restricted right, but also in some senses the highest right, because it really is important. It's expressly mentioned in the code about protecting the public from being misled. And now we get to the second public interest, which is his right of reply, which is triggered by the attack. Lord, I'm not going to go over old ground. I've made extensive submissions about right of reply. But can I just emphasize this point about autonomy? If you attack someone or cause somebody else to attack someone, and the attack refers to an ostensibly private document of yours, which certainly contains material relevant to the kind I've indicated, you're plainly loosening your autonomy. One can have a fascinating philosophical debate about whether allegations against Mr. Markle in the letter, are they shared information, are they her information, what exactly are they? But whatever they are, if the law acknowledges the importance of a right of reply if you're publicly attacked, you must be loosening your autonomy in the information, assuming for the sake of argument I'm right about the letter having some, or more than some, having real relevance to rebutting the attack, you're necessarily loosening your autonomy.
Well, are you criticising the judge really for not looking to see what the attack on Mr. Markle was, but only looking to see if there was anything in the People article that was inaccurate?
Yes. Yes, well, we are, because we're saying the attack on Mr. Markle is wider, and part of the problem is that to take what in some ways might be thought to be the most hurtful thing about the pre-wedding conduct, he doesn't really go there at all.
But you're also, the problem that is your elephant in the room is that the letter is not automatically to be taken, as you assume, as a further example of bad conduct by the Duchess. The letter, the Duchess would say, I'm sure, was an attempt to put him right, absolutely, about the press, but was not unloving, not unkind, just justified. So your assumption is that this letter, which is in her eyes loving and fair, putting him right, in your eyes unfair, says bad things, says wrong things about various tribal issues about the wedding, is a sensible or reasonable rebuttal of those points, when really it's just more of the same of the People, isn't it?
Well, look, with respect, we simply don't agree. I mean, there's another facet to this, of course, which is the fact that the letter was given to the People and the judge accepted. We had a triable case.
No.
Sorry, not the letter, I beg your pardon. That friend A spoke to the People to whom she had spoken, and that we had an arguable case that she was responsible for the People article.
Yeah.
Now, it is a very curious position that merely because you don't give the text to the People, the text doesn't appear, but you give a misleading summary of the letter, which is bigging you up and pushing him down, that the letter is somehow wholly immaterial.
Wasn't it enough? I mean, why? You know, I'm as you probably worked out, Mr. Caldecott, I'm quite struck by this part of the article where there are extensive citations from the letter, followed by Mr. Markle's comments. And why wasn't it enough for Mr. Markle to make his comments by reference to saying, and she wrote to me again, or she wrote to me telling me off, and this is what I say about it. You know.
Well, what are the readers to assume as to where the truth lies unless you can see the letter? If I was a judge trying to investigate where the truth lay, you would want to see the letter. And the public are in no different position.
Well, except she's got a right of privacy in the letter.
Well, your Lordship assumes that. Well, we don't accept that, as your Lordship knows. We've very much been focusing on my learned friend's submissions on this started off assuming privacy, but it's a very nice question. If you start, as we plainly the judge accepted, we had an arguable case for trial, that she was in the broad sense behind the People article. The People article does two things. It firstly repeats some allegations in the letter which we say are untrue, and secondly it produces a wholly misleading gloss on the letter to her credit.
Doesn't it just, I mean, is that to do with the letter? Or is that just a wholly what you say to be a wholly misleading gloss on the person? I mean, is it, I mean, we need to look at this, but it doesn't seem to me that the 25 words in the People are what you're, if I may say so, saying about them. I mean, that's not the whole thrust of it. You make it sound as if the People article is just based on the letter. Whereas the People article, if we look at it, I think it's page, is it 343 or something like that?
377 is where the crucial text begins.
Right, and it's in the second column, 377. There seems to be more of it than I remember, maybe. It's the right-hand column.
Yes, well, it is, my lord. It's all bound up because there's the appalling treatment of him alleged in the opening section, and then in the second paragraph, immediately after all this business about him wholly ignoring her, I love you and I'm scared, it was endless. After that, after the wedding, she wrote him a letter. She's like that, I'm so heartbroken, I love you, I have one father, and so on and so forth.
But what I'm putting to you is, this is an incredibly long, somebody's going to have to tell me what is the People article, I'm afraid, because there seems to be so much of it, I hadn't realised it goes on for pages and pages. Is that all the People article?
Yes. Lord,
yes.
As I understand it, there's a hard copy magazine version of it which runs to page 382, and then there are online articles at 8, 9 and 10 o'clock following, I think on the same day.
Right.
And I was showing you, Your Lordship, one of the, I think the 10 o'clock one.
You see the point I'm making. If you look at, I don't want to interrupt your flow, Mrs. Caldecott, but it does trouble me, and your submissions would be helpful. You know, looking at the other pages, which we haven't trawled through, it's all about what a wonderful friend and person the Duchess is, right? It's nothing to do with the letter at all. She's funny, makes the room laugh, she's selfless, she's very kind to people, and so on and so on. Pages and pages and pages.
Yes.
And so why would you, in rebutting the suggestion that even about Mr. Markle, you know, it's super painful because she's so dutiful, she's devastated. The rebuttal, why does it have to involve the letter, really? What's that got to do with it?
I mean, it seems to me that...
I mean, why can't he write it? He can ask the People to publish, or the Daily Mail, or anybody he likes, to publish a rebuttal saying, I'm a very dutiful father, and she wasn't what she said she was.
Yes.
Or am I missing something?
Well, I think with respect, one is.
Okay.
Because it is just worth looking at how the Mail article opens what it says, leaving aside the...
So are we in the Mail or the People?
In the Mail, just for the moment, because this is, as it were, the reply.
Mm-hmm.
And you'll get the first three. Mr. Markle says the letter, but paragraph 4 today, far from conciliatory, has left him feeling devastated. The bombshell 5-page letter lays bare the true depths of a father's estrangement. She accuses him of breaking her heart into a million pieces. And then there's a bit about his talking to the press. And the article is fair. It acknowledges, it does mention material in the claimant's favour.
But the problem with the article is that what the article is about is a big splash. It says in the first paragraph, the full content of a sensational letter written by the Duchess of Sussex to her estranged father shortly after her wedding can be revealed for the first time today. It does not say this is the response of Thomas Markle to vile allegations made against him in the People magazine, which is not what it's about. It's about splashing the letter. And they say, well, you know, you knew it was her letter, you knew there was a right of privacy, you're journalists, you had a responsibility to ask her if she minded her letter being splashed all over the tabloid newspapers, and all you did was make it into a big article.
Well, I'll come back to the notice point, which, as we'll see, has no merit at all.
Well, it's not that it has no merit, it's a fact, isn't it? There was no notice.
Well, anyway, I'll come back to that later as to what my friend said about it. Can I just, the big column just under the photograph how Meghan's media fight back led her dad to reveal the letter he wanted to keep secret. Remember, he'd honoured the privacy in this letter until the People article appeared. The Duchess's father told no one about her letter and planned to keep it totally private out of respect for her until her friends launched their attack on him last week. The article painted Meghan in a glowing light while insisting the negative stories about her were lies. But Miss Markle says the decision to reveal the letter left him with no choice but to go public. The letter was presented in a way that vilified Meghan wasn't true, he said last night. It was presented as her reaching out and writing a loving letter in the hope of healing the rift, but the letter isn't like that at all. Either we believe in freedom of expression or we don't. But Mr. Markle has been royally attacked in the People magazine in precisely the way he there describes. And this is his reply. What goes through the early columns, it goes through various allegations.
Yes.
And as your Lordship rightly said, and gives his reply. Now that, it brings me again, in a sense, to the wider public interest in this case. If you read the People article, you don't know for certain to what extent the allegations were authorised by the claimant or not. It says friends very close to her. Now, there's particular significance of the pre-wedding allegation, which is false, is that it can only be known about, essentially, by the three people who were party to the essential communications, which is the claimant, Prince Harry, and Mr. Markle. So it's perfectly reasonable for Mr. Markle to assume that the claimant was responsible. And also, one would have thought quite reasonable for him to assume that the five friends did have her approval to state these private things on her behalf as the truth.
The judge assumed that.
Yes, yes he did, but it's all part of the fabric of enabling him to deploy the letter. And there is this core difference between this case and the Prince of Wales case. In the Prince of Wales case, documents marked strictly private and confidential were taken to the mail by a servant who was under a contractual duty of confidence. And the court took the view that it was essentially the prince's private thoughts or private reflections on his travels. And although there might be some public interest, it couldn't outweigh, and therefore they gave summary judgment. But this letter comes to the newspaper in very different circumstances. It comes from someone who on the face of it has got a right to reply, and what they are doing, effectively the Mail, we say, is giving him an opportunity to do so.
Well, I mean, that's fine, but it's what tools you use to reply, isn't it? That's the key issue here.
It is the key issue here,
He's
but
perfectly entitled
yes,
to reply.
but this is a very important case about the ability to deploy private text which is relevant. Can't be said. How could the letter possibly be said to be wholly irrelevant to the issues which are being raised by the People magazine?
Who says that? Who says wholly irrelevant?
Well, Lord, it's an important question. My learned friend says it's wholly irrelevant because it doesn't show anything by way of rebuttal.
I'm not sure he says wholly irrelevant. It does show some things by way of rebuttal. As we know, it shows, it rebuts the allegation that it was an olive branch.
Yes, I'm obviously I've conceded the olive branch is, that's something the judge, he let in one paragraph of the letter, I think it's 15, on the olive branch basis. But we say that's far too narrow. I mean, this has really quite important consequences for investigative journalism if it's to be said it's unarguable that you can deploy the text of a material document which is ostensibly private in circumstances such as this.
To what extent does it matter that in your paragraph 15.6 of your re-amended defence, you referred to the fact that the matters you set out were relevant, you say, to Mr. Markle believes and has informed the defendant that this was wholly false. In other words, that you didn't say it yourself, because that's dealt with by the judge. If one looks at this part of the judgment,
yes,
I'm dealing with paragraph 111 and 112, and what he's looking at when he deals with your case on this is what you've pleaded, what your case is on the pleadings. The starting point is it's assumed that the claimant has some responsibility for the references to the letter in the People article. That's assumed in your favour. But, and then he then goes on to say in 111 and 112, it's hopeless. And he says if a published article gives a one-sided account of a relationship and that account is false or misleading and damaging to a person, that might prove some justification. But there's no authority to support the view that mere fact the person believes.
Lady, this is unfortunately, there is some, and I accept there is some merit in the judge's view, and I'll come to it if I can just find the page of my earlier submissions. I didn't go into all of this because, of course, I'm slightly running out of time, but there's a whole raft of pleadings about this, and it's fair enough, I think, for the judge to say that at times there's some slippage between objective falsity and a subjective reasonable belief in the falsity. But there is also a fair amount of objective falsity. There are a whole lot of references to the pleading which deal with this. Yes, I know. I just want to find them because I've got a list of them. Yes, my lady, could I just answer your question? And it's a perfectly fair question. If one goes to the defence at CB2, I'm sorry, tab 21.
Page.
Page 329, I think is the best place to start. And a whole host of paragraphs which need to be looked at. Can I just say this before going to them? All the relevant texts are set out in the defence. 13.8.6, the plain meaning and effect of the hard copy article, the 10 a.m. People article, was to suggest that Mr. Markle has made false claims about his dealings with his daughter and that he was entirely at fault in not attending the royal wedding and for the estrangement between himself and the claimant. 13.8.11 is a point about not complaining, not seeking to put it right in People magazine. And then 13.8.11a, on the day the People articles were published, Mr. Scobie appeared and said no true friend of Meghan's would speak out publicly without her very subtle blessing. Mr. Scobie said that while the purpose of Miss Meghan's letter was very much to repair the relationship with her father, she knew in her heart of hearts this was going to be released to the papers, so many of these things in the letter were written with the public in mind. And then in 15.4, and then we can forget all these long particulars. If we go to 15.4, this is an important paragraph. The People interview depicted Mr. Markle as having acted unreasonably and unlovingly, having cold-shouldered his daughter, and being solely to blame for the estrangement between father and daughter. This was a one-sided and or misleading and false narrative.
And I follow that. So then, if one goes on to 15.9,
Yes.
this is where we deal with or you deal with the, what might be called a contrast between what's in the letter
Yes.
and in the People article. Is there anywhere else that we need to look at for this purpose, where you deal with this in your pleadings, that issue, a contrast between what you're saying positively as opposed to through the mouth of Mr. Markle's
There's
belief?
another one, 15.8. Your ladyship, look. People also stated that Mr. Markle refused to get into the car, suggesting he'd refused to attend his own daughter's wedding. This was also false. 15.9. So we can repair our relation. This is more on the olive branch, I accept. This information was false, as is now admitted. And also in 15.9,
And then we've got the
about the loving letter, and this was false. It wasn't a loving letter. The ladies, I think the judge was critical because there are occasions, and 15.7 is an example, where it says never called and never texted, and that he'd falsely claimed that he couldn't reach his daughter was, according to the claimant's father, untrue. But there's an air of unreality about this, because after this original defence was served, all the texts came in attached to the re-amended reply, and they, we say, plainly demonstrate, or arguably demonstrate, that this allegation was plainly false, that he never texted, and it really would be completely unreal to approach that issue on any other basis. And then just to give, I think Ladyship asked any other.
photo op in 15.10.
Yes, 17.8.2. The words in Article 2 that the claimant had blasted her father for not telling her that he would not walk her down the aisle would be clearly understood to be an interpretation of the words of the letter quoted immediately after. It was true that the claimant had accused her father in the letter of not calling to tell her he would not come to the letter, as is apparent from these words.
Well, what I'm really looking for is the parts of your case which say this is what the letter said, and this is the fact. The
15.9 is perhaps the most important.
yes, thank you.
You've been using the phrase a loving letter. Is that your summary of the gist of the italicised words in 15.9.234? Dad, I'm so heartbroken, I love you, I
Yes.
have one father.
Yes. Now, there is interesting point here on the Article 8-10 balance. The learned friend did not challenge, I'll be corrected if I'm wrong, our criticism of the judge for saying that the effect on Mr. Markle was modest. Did you? Yes. Well, we submit, and I said it in opening, all sorts of reasons for assuming that it is at least arguable that when he said he was shocked, and you can read his witness statement about it, no reason whatever to doubt that he was telling the truth. And the ladyship quite rightly pointed out that Article 8's core value actually is about the ability to interact with our fellow human beings, and the loss of dignity and so on, and loss of autonomy can affect that. But if one is actually looking here, balancing on the one hand the real weight of the loss of privacy in the letter, if there were any, against the effect on Mr. Markle's Article 8 rights, both his family life and his reputation and his ability to interact with people, we would say the balance on any humane view comes down firmly on his side. And that is a real problem with the judge simply saying the effect on him was modest. There was no evidence on which he could properly base that, we say, and in regard to the seriousness of what is being said against him. Now, can I just say this while I'm on it about the wider public interest? In fairness to the Mail's article, it does give points from the letter which are in the claimant's favour. It does explain that she was right to criticise him about the paparazzi photographs, and it also refers to the later interviews he gave as damaging. It does not give a wholly one-sided view of the debate. I mean, it's often said against newspapers that they simply just give one side, but they do give that side of it. This raises another issue about the letter. Anyone reading the People article would be interested to know whether or not the claimant was a co-accuser. Was she in any way herself making these allegations? That is a genuine matter of public interest. And she was indeed the source of the allegations about the pre-wedding period. And in view of her position, it's a perfectly proper public interest to show that she was, and that requires deploying the text of the letter to make that wider public interest point. I may add that her deployment of the letter, as to which we have an arguable case, I mean deploying it in the broad sense with the People, is plainly a relevant factor at the first stage under Murray and under the Code. It's a material disclosure of information to this particular debate. And it's clear that the editor is told by Mr. Markle that he believes his daughter behind it, but you've only got to look at the allegation, particularly about the pre-wedding behaviour, to see it would be very surprising if she had nothing to do with it. Now, either freedom of expression is now so downgraded that you apply a pretty granular analysis, you ignore parts of the sting to which the letter is plainly material as a rebuttal. And if that is so, we respectfully say that is a material change in the proper approach to the balancing exercise. Which brings me to a point on Campbell. What lost the defendants that case was the fact that publishing the photographs interfered with Miss Campbell's medical treatment, because she would not go back to her Narcotics Anonymous base she'd been visiting for fear that there would be long lens photographers waiting for her. That case was decided very firmly on that serious interference with her treatment, and the majority judgments are all about the intrusive effect on her treatment. That was the decisive factor. Where is the equivalent factor in this case? There is nothing even approaching that kind of seriousness. Now, my Lord, I hope that's really my submissions on the main question. Except I should just deal with one further point about why this is quite important. The learned friend said that the book account of the letter was simply taken from the Mail on Sunday. These untruths keep appearing about Mr. Markle, and this is another reason why getting it out there is important. If you could just look, please, very quickly on this point, at Supplemental Bundle, tab 11. Bear in mind that the claimant admits that she spoke to a friend with a view to her talking to the authors about the letter. If you look at page 99, you just look at the second paragraph. This is what happens if you can't even deploy proper defensive material. Despite Meghan's barrage of voicemails and texts, Thomas had not only refused to get in the waiting car to the airport, he hadn't responded to a single message from his daughter. Now, that's not reproducing the Mail article, it's wholly ignoring it. And then there is a reference to one particular text which is on page 101. First new paragraph on page 199 of the book, 101 of the bundle. With only 4 days left to her wedding day, though, Meghan received more devastating news from her father, again through a celebrity gossip website. To be fair, literally that's true. The website got there first. And then go down another paragraph to the middle of the page. Troubled, Meghan reached out to Thomas via text message. I've been reaching out to you all weekend, but you're not taking any of our calls or replying to any texts. And then 10 minutes later, she followed up with another. And then at the bottom, that evening, Thomas sent a short response saying that he appreciated the offer of security, but didn't feel in any danger. Instead, he wrote he would recover at a motel. Meghan asked for details, but he didn't reply. But he did reply. The text is at 6:43 at 4 o'clock, and he told them exactly where he was staying in the hospital. Why should the traffic on this be all one way against Mr. Markle without him showing this comes this comes from my daughter. Look what she said in her letter about this. Look at the text, which is what the Mail article sets out, the crucial 16th of May text. I did tell my daughter I couldn't come to the wedding. I was very disappointed about it, and so on.
We're not talking
I'm
about...
so sorry to interrupt, my lord, but my learned friend may not realise that the deployment of the text messages in the book all comes from the fact that they were annexed to the reply in this action. Regrettably, they were not protected by confidentiality. We've been around the houses on this before. That's where the author's got to. I don't know why my learned friend is making a point.
Well, no, I'm making a wider point than this. I'm not suggesting that the claimant caused this, but there's no plea to that effect. I'm pleading a much wider point about the public interest, about the importance of bane and antidote, and about the public having the wherewithal to make a full judgment about this. Is it just the friends who are putting it out? Is it her? Where does the truth lie? And I may add this, that the texts to which there is no objection in the article are private communications. They are part of the story. They are deployed. But there are very important and deep issues in this case about the use of ostensibly private material that has been deployed in the public domain in a misleading way, and how far the use of it can go. I'm not going to say any more about this point. Can I just move on to the precipitate point, not least because my Lord the Master of the Rolls raised it about not giving notice. The first thing to say about this is the code imposes no obligation to get consent. What it says is that you have to have a reasonable belief in the public interest and so on. If you've looked at the code, if you're going to publish private material without consent. Now, this is particularly so in the context of reply to attack. Because what happens if you go to the original attacker, the reply then gets polluted with a whole lot of secondary material from the original attacker. The purpose is to give Mr. Markle's reply. That is the purpose of it. Thirdly, the European Court has ruled on this very point in a case called Mosley. Can I just hand up 3 copies?
Can you send it electronically?
Well, certainly, of course we will, yes. It's been sent, my Lord. I hope it may have arrived.
Not yet, but... Oh, yes, maybe.
It's very last paragraph of, sorry, no, I beg your pardon, hasn't arrived yet. Lord, we really only need to look at 132. The court has consistently emphasised the need to look beyond the facts of present case and to consider the broader impact of a pre-notification requirement. The limited scope under Article 10 for restrictions on freedom of the press to publish material which contributes to debate on matters of general public interest must be borne in mind. Thus, having regard to the chilling effect to which a pre-notification requirement risks giving rise, to the significant doubts as to the effectiveness of any pre-notification requirement, and to the wide margin of appreciation in this area, the Court is of the view that Article 8 does not require a legally binding pre-notification requirement. Accordingly, the Court concludes that there has been no violation of Article 8 of the Convention. Lord, Where pre-notification does matter is in the defamation context, if, and I stress if, you wish to avail yourself of the defence under Section 4, used to be the old common law public interest defence. But if you believe that something is true or something is in the public interest, you're entitled to publish it, and there's no obligation to pre-notify.
The judge dealt with these sort of points, paragraph 125.
Yeah, the precipitate point.
As part of a sort of, because he says he accepts in principle it was legitimate for Mr. Markle to seek to rebut the inaccurate suggestion that the letter represented some form of olive branch, and having earlier said it would in principle have been legitimate for Mr. Markle to reply to the allegation of victimisation. The point he was making is that it wasn't necessary or proportionate, so it comes in as part of the proportionality analysis at 125.
Lord, yes, Lady, yes, sorry, and that's, there's an issue between us about that. We say that's much too narrow.
Well, what do you mean much too narrow? I mean, he is saying it can't possibly be proportionate for these two allegations on any analysis to reveal the whole of this large tracts of the letter, because the letter is more of the same as the People article, and it's these are fairly narrow inaccuracies that he's replying to. Now, I know you say there were broader inaccuracies about the wedding and the cold shouldering and so on. But what is the legal error here? I mean, you say he's just weighed the balance wrong. You say it could be enough to allow, on a proper analysis, the whole letter in.
I say that Mr. Markle's Article 10 rights to give his version of events were strongly engaged because of the nature of the attack on him. And I say that the fairly extensive quotes from the letter, I accept, I think it's about half of the letter, are fairly relevant to getting an overall picture. And court, and I do say that it's far too narrow. And one of the reasons, I mean, there are many reasons why it's too narrow, but I mean, my Lord puts to me that, oh, well, you know, he may not have spent much time on the allegation about the pre-wedding communications. The pre-wedding communications are extremely serious. We say demonstrably false. They're in parts of the letter which the judge said, for example, he was not allowed to deploy.
But I mean, the deployment of her letter to defend himself is strange when he's got a lot of text that he wrote that he could have deployed to defend himself. And what I find strange in all this is that you're not really, what you're, if I may say so very skillfully, Mr. Caldecott, as I'd expect, doing, is extending the ambit of the debate from whether Mr. Markle was entitled to defend himself vigorously against a 10-page attack in the People magazine saying he was not a good person, to make it sound as if we're opening the floodgates of destroying freedom of speech if we don't uphold your appeal, because he responded by using a letter which was of some relevance but not absolutely central to saying I'm a good person and you're wrong to say I'm a bad person. I mean, it was just one tool, and what the claimant says is it was a tool that belonged, that had a property right and also a privacy right in me. And you could have said all sorts of horrid things about me if you'd wanted to, and indeed you did. But you didn't have to pin it on the letter.
The fact it may be that he didn't have to doesn't mean that he can't.
Well, of course, that's right. If you're right, you're right. I mean, I accept that. But the point is that the article, I mean, you haven't really, your answer to my question about the way that the article is pitched is to refer to a sub-headline and say this is a response to the people. But actually, if you were reading this article, you'd read the real, you'd read the real headline and the first part, which is actually about publishing the letter and saying it's a bombshell. And I think, you know, the people is coincidental, really.
Can we just look at the article, quite apart from the section which I drew attention to, just look at the opening paragraphs, the opening column of the article.
I know it gets to, well, paragraph 5, the bombshell 5-page letter. True depths of the Duchess's estrangement. And this doesn't look like a response, does it? I agree it's pinned on the response, of course, but the point I'm making to you is that he could have responded without the letter, and the world would not have ended on Friday if he'd done that.
Your Lordship may of course be right about that, but where's the editorial latitude coming into all of this?
Right.
I mean, what Lord Hoffman says, I do repeat the point that if one look at the Article 8 side of it, there have been, plainly on our case, there have been material disclosure of information by her, material to this debate. And on the Article 10 side, if you look at Lord Hoffman's analysis, that you have to look at both what is not complained of in order to assess whether it's right. And also think of the reader's perspective. How are they going to believe Mr. Markle if he simply describes the letter?
Well, I mean, my point is a different one, really. What's really the letter hasn't got much to do with it. It's a long People article, which is a diatribe, and the answer to it is, you're wrong and I'm right, and all sorts of texts, and it's not true, and I did write to you, and I did phone you. It's really nothing to do with one letter. I mean, there is an allegation or two allegations about the letter, but the People article is not based on the letter.
Well, but we respect the People article, the relevant part of the People article is heavily based on the letter. Obviously not exclusively.
You're the one who's urging us to take the thing in the round.
Yes, I am.
And if we take the thing in a round, then we don't just look at one paragraph of a letter.
No, absolutely. But I was in the People article. The letter is the crucial link between bad behaviour before the wedding and then bad behaviour after the wedding. It sits in the middle.
Yeah, and then there was a letter. It's really about the bad behaviour.
Well, we, with respect, don't agree. He's portrayed, quite agree, he's portrayed as guilty of bad behaviour, and the Mail article points out that in some respects, that's a true bill, in some respects. That's important to the wider public interest. It is important. It's, in that sense, a balanced view, whatever one takes the view about the deployment of the letter. But the letter, for the reasons I've given, is weighty evidence that the high presentation of the claimant's conduct, which, as I keep repeating, is intimately bound up with the way his behaviour is presented, is untrue and misleading, and the letter shows that.
Right.
I suppose you say your case is summarised by Mr. Markle in the centre of the page of Caroline Graham's article under How Meghan's Media Fight Back Led Her Dad to Reveal, etc. He said the letter was presented as her reaching out and writing a loving letter in the hope of healing the rift, but the letter isn't like that at all.
Yes.
You can't have it both ways. You can't use the press to get her message across, but hang me out to dry, I have the right to defend myself.
Yes.
That's putting in layman's language what you've been saying to us,
This is
whether it's
pretty
right or not.
It's
I
every
don't
bit as
know.
well as I put it, actually. But the judge simply doesn't analyse this broader case at all. Nor does he engage with, as I say, some crucial issues of falsity. He lists the texts which reflect badly on Mr. Markle in terms of the paparazzi photographs. The texts which are favourable to him are nowhere. And as I repeat, and I've
And I
come
think
back
in opening you were putting quite a lot of emphasis on the fact that the judge was apparently concerned with the press coverage. So was concerned with the question of the argument about whether Mr. Markle had been to the press when he shouldn't have been, and what he had done in that respect, whereas that was not the issue you were complaining about.
Yes, it's legitimate background. I don't criticise the judge for mentioning that, not least because it's in the article, and it's right to say that Mr. Markle himself does not have a fully luminous halo in this matter. But he's not so portrayed in the Mail article either.
Yeah.
And just in answer to your lordship's one other question or observation on the suggestion about notice, I hope I've answered it fairly thoroughly already. There was here a fair amount of urgency. The People article appeared on the 6th of May. How many millions a week? 40 million readers a week is what it has. And it was immediately picked up by the world's media worldwide, leaving, one would have thought, Mr. Markle in a pretty lonely place. He's an ordinary citizen. He may have given the odd ill-advised interview, but he doesn't have the command in the media which someone like the claimant does. And we say there, in journalistic terms, was a perfectly legitimate urgency in the Reynolds sense about getting his reply out there. And what Lord Hoffman, I think it's Lord Hoffman, says, I don't say this in a defensive spirit, but newspapers do have to make, we've been discussing this now for 2 days, but the newspapers have to make a very quick decision on the material available to them. And Article 10, as Mosley implies, and I think Lord Hoffman and others, I think I took your lordship to the cases, to the extracts from Campbell, have to make a decision in short order. The finding by the judge on this is really astonishingly dismissive. What was done was precipitate, largely irrelevant to any legal aim, making the fullest allowance for editorial judgment and wholly disproportionate. We do take real issue with that. And it does bring me to the important legal point that we have on the question of burden of proof and necessary. And I made the point in opening that necessity is a very high standard in ordinary language. Now, the learned friend, could I just add to my note, my lord, there's one paragraph I should have put in, which in one sense is the first one, which is J35. It's in point 5 of my note. Your lordship rightly pointed out that J35 is another important, or paragraph 35 I should say, is another important paragraph in this. Now, the learned friend pointed I think, to two. First of all, he pointed to 104. The last sentence in particular, but that's dealing with the test for summary judgment. It's not dealing with the test under the balancing exercise. The last sentence of 104, if there's a real possibility that the publication complained of might be found justified on this basis after a trial, I ought not to strike out or grant summary judgment. And then he's referred above to preventing the public from being misled, and that's the big issue we've been debating for quite a long time. Now, 106.4, sorry, beg your pardon, that's a miss. And then it is 106.4, I'm afraid it's actually in the text. Whether the publication was necessary and proportionate in pursuit of the available justification. That is what the judge is saying he has to assess. That's not right. Now, in Campbell, when the judges are looking at the facts, bearing in mind the harm caused to Miss Campbell, it's not surprising they said it wasn't necessary to do it. But they weren't laying down the test. The problem with what the judge does is that he's using this as a basic yardstick, and it's much too strong. And then 112, we see exactly the same in the last sentence of 112. This is one of the paragraphs I take it we've discussed already about reply to attack. It's fanciful to suppose that the court would find the disclosure of the contents of the letter necessary or proportionate on the basis set out there. And then 119, this appears to be suggesting what the editorial judgment
Will you
should
say
be.
that's wrong as a matter of law?
Well, I say that that seems to be going back to the error which we identified earlier about a burden and about necessity as the standard. And again at 119, this looks as though the question that the editor should be asking himself is whether it's relevant, necessary and proportionate. Making the fullest allowance for editorial judgment made it relevant, necessary and proportionate to make the disclosures complained of. It's the word necessary which is the particular problem. Then again, 1255, it was neither necessary nor proportionate to disclose any of the rest of the information in the letter for this purpose. It's a more generous test than necessary. And your Lordship will remember that even in the majority judgments in Campbell, they say it's not enough merely to say it would have been reasonable of the editor to have done it differently. My Lord, I appreciate.
Well, the test for correcting what's on the public record, What is that test? Which is what the paragraph was dealing in, the judge was dealing with in 125. What test should if the court is
Give me a moment.
court is looking at that issue?
Yes, I just need to clear a couple of files. Sorry, I got a lot overloaded here. The test appears to be, if one takes the code, and that's what the editor is meant. That's his guideline.
Part of the
Well, it's part of it.
legal framework.
Yes.
It's not the only, but I want to know
it's
what
a
you
helpful
say.
starting point, because Section 12 requires us to have regard to it, and it is a code which is where they look if they have a problem. And what paragraph 4 of the code on page 1036, Authorities Bundle 2, tab 40 says, will need to demonstrate that they reasonably believed publication would both serve and be proportionate to the public interest, and explain how they reached that decision at the time. Interestingly, and sorry, you were about to, it's my fault,
I just want the answer to the question.
Well,
It's important to know
yes,
what you say.
yes.
You're criticising what the judge did, and I wanted to know
Yes.
in a sentence what you say the test is, that it should be applied here.
But we say that the test of reasonable belief that it's in the public interest it would appear to be the test one must have regard to. It's what the code requires. It's interestingly what both Section 4 of the Defamation Act requires, and it's what Data Protection Act, which is a privacy statute, the reasonable belief by the editor that it's in the public interest is what data protection requires. So there is some synergy between all of this.
You don't say it's a proportionality test.
I think if he should reasonably believe it's wholly disproportionate, then I think I accept there would be a problem. If he should, on a reasonable assessment, realise it's wholly disproportionate, then I think there would be a problem. My problem with the judges is not so much with the word proportionate, but the word necessary, which I hope is the word I've been stressing. Of course, has to be read with Roman 3 if one's dealing with the case of the public being misled. Well, the injunction example is, with great respect, wholly unhelpful. A learned friend gets up and says with his great experience he would have got an injunction. I get up and say with my great experience he wouldn't have done. And it takes us absolutely no further. But can I just say this? It does raise some interesting questions about what facts would the claimant have disclosed to the court if this hypothetical injunction had been applied for. Would she have told the court that this letter was written with a view to public consumption if Mr. Markle leaked it? A point, incidentally, I have not referred to at all, but it's surely highly relevant to the 8-10 balance that there's a public-facing aspect to this document. Fully accept that it wasn't known to the newspaper at the time, but the test is looked at in all the circumstances as they emerge before the trial. Would my learned friend have been saying to the judge, I should tell you that the letter does rather misrepresent the position in the run-up to the wedding. If he did, I think the judge's eyebrows would begin to rise about the public interest really in protecting this letter. is he telling the judge that the letter was deployed in the People? And incidentally, on notice, the newspaper did ask Kensington Palace before publication whether or not the claimant authorised the People article, and they got no response. And it's in the article. And it's paragraph 16 of the first article. I'm not suggesting they said we're going to publish the letter, but they did ask Kensington Palace that question. Paragraph 16. The article, I'm afraid. But Milady, it really doesn't. The injunction, the hypothetical injunction applications are highly entertaining.
Sorry, Andrew, can you just give me the reference? It matters. This was not brought to the claimant's attention before publication.
It was raised in correspondence right at the beginning, I think before shillings were.
Well, we can't resolve that.
No.
Not pre-publication.
The Murray factors, I'm not going to spend any time on them, but they have rather shrunk into the background. Dealings with both the letter, we say, and certainly, and also the text of the letter are relevant. Now, what has happened was, that your court will remember, the first Addleshaw letter was before the judge, saying there's relevant information to be given on 3 issues, and I'm not going to go back over this ground, but there it was. Now there's still another letter from Addleshaw letter saying the other 3 have got relevant evidence, but they have declined to produce it at this stage. Now, the interesting point is that the first Addleshaw letter, and I think I pointed this out, includes that the palace staff can assist specifically about her intentions, I mean the claimant's intentions, in relation to the letter. It's in the 3rd bullet point, I think it's supplemental bundle 12, isn't it? I think it's supplemental. It's supplemental bundle tab 12. And it appears that all of them can potentially give evidence. The first bullet point, as I pointed out at 129, we needn't worry about its copyright. Whether or not the claimant anticipated the letter might come into the public domain, and whether or not the claimant, generally and in relation to the letter specifically, to the authors of Finding Freedom. That is not dealt with by Mr. Knight, so there must be more evidence to come on that issue. Now, it would be extremely odd if that evidence is in effect no evidence. You don't say I can help and then turn the lights off. There must be some material evidence yet to come from the palace staff in relation to this important issue. And I just give the court the reference to the Kensington Palace refusing to comment on the sources for the People article. That's at 13.8.9 of the defence. at page 329. I'm grateful to my juniors. Is there anything else? Yeah. Lord, this obviously is relevant to the easy air notion that further evidence may be available which might affect the result, particularly bearing in mind that the editor is entitled to have regard to other material disclosures. Lord, I know that Mr. Speck has a few enlightening words, no doubt. Thank you very much. Is there anything I can assist you on further?
No, thank you very much, Mr. Caldecott.
Lords, my lady, they are very few, and I'm going to take it at quite a pace, if I may. The first point I just wanted to respond to was my other friend, Mr. Mill, was trying to suggest that the judge did address the weightiness of the right, and he gave you three references in the judgment, paragraph 139, 148, and then 155. 155 was the sentence that I'd already dealt with in the fair dealing part of the judgment, which is actually looking at proportion, and you have my submissions on that. The earlier two paragraphs are directed only to the question of whether or not the threshold is met such that copyright subsists. It is not addressing the question that I was addressing, which is the weight of any such copyright. That's point number one. The second point is that my learned friend, when talking about Ashdown and my submissions distinguishing it, and in particular my submissions that Ashdown was a case where the only argument was about authenticity, went to our pleading at paragraph 1514 and showed my lords and my lady a paragraph referring to authenticity, and then proceeded to argue the case as if that was the entirety of what we rely upon. That's not so, and it's important that my lords and my lady know. You've been looking at a few of the paragraphs that I wanted to just show you a little bit earlier in my learned friends' submissions. In the amended defence, around about paragraph page 343. In fact, I'd also rely on paragraph 15.4 that my lady drew my learned friend's attention to, and 15.9, specifically there is the guts of the way in which my Lord Justice Bean identified the case, the loving letter and the olive branch depiction, 15.9. 15.13 is the allegation that the publication was in direct response to the People publication. And of course, perhaps most crucially, is that jumping over 1514, which my learned friend tried to portray as our only reliance, if you go to 1516, exactly what I was submitting to you is there. It's Thomas Markle's right to tell his version, including the contents of the letter. But that's obviously all in the context of those earlier paragraphs. So my learned friend's attempt to make it look as if our argument is just that run in Ashdown completely fails, and it's just not fair in my submission to pick out one paragraph that mentions an argument as to authenticity and to suggest that my argument is just no more than that. So that's the next point. The next point I've got on my list is the question of why have a trial? Well, all the submissions that my learned friend's been making on the weight of free speech, all the submissions that we have in the privacy side of the case, which clearly go to fairness, arguments about what might be possible to take as the structure point about taking more is actually less objectionable. There are many reasons why one would have to have a trial on copyright as well as the privacy. That's the third point. The fourth point, my learned friend suggests that when the issue is the tone and content of the letter. One can just describe it. It's pretty obvious in my submission that one cannot do that in any way that is convincing, particularly somebody in Mr. Markle's position, who had been somewhat vilified in the press before, to just simply say, actually the letter that I got is not the loving letter that is being depicted. It's important in my submission that he is able to say, look, this is the content of the letter, and that pretty much mirrors the thrust of the submission that my learned friend was making about how it's important on the free speech privacy balance too. In meeting that broader sting of the People magazine. The next point, very quickly, my learned friend mixed and matched. I wasn't quite sure what he was talking about in terms of whether he was addressing submissions to fair dealing or the balance with free speech at certain parts. He referred to the passage in Laddie at a part of his submissions where I think he was talking about the balance with free speech. That passage in Laddie is all to do with fair dealing. It's nothing to do with the free speech balance. Next point, he mentioned the handwriting article. The handwriting article he lumped together, or is happy to do so, and he's doing that because it is in fact one of 3 online versions published of substantially the same story. I'll give my lords and my lady the reference to Mr. Verity explaining that that is the modern practice of publishing online. You publish more than one at very close intervals in time. And just as an aside, that's exactly what you see with the People article. That's why that tab that my Lord the Master of Rolls said is so thick. What you've got there is the hard copy, and then you've got 3 versions online published about an hour apart. And you've seen the very last one focused all on the father. The middle one was focused on the same material but with lots of photographs, and then there was a shorter online one. But it's the modern practice, and in fact on the handwriting article, just 1 sentence was used for the handwriting analysis, and the rest of it is very similar to the other articles, covering the other stuff for the same purpose. The Article 10 rejection, my learned friend tried to say that the grounds for fair dealing and Article 10 in our pleading are substantially the same. I'd anticipated what he was going to say about the paragraphs relied upon as the underlying narrative, and that's why I said the underlying narrative paragraphs are either the same or very similar. But the actual grounds that are pleaded are materially different. The grounds, as you saw in the pleading, are different, and in particular, under the Article 10 balance, has a specific reference and reliance on Thomas Markle's free speech rights. And the very last submission that I needed to answer is the pro-sebum point. My learned friend suggested that my submission didn't help because I didn't get into overturning fairness by the submissions that I made. I was surprised at that because I'd already submitted quite separately to my lords and my lady as to how the conclusion on fairness couldn't possibly stand by, do you remember, attacking those 4 factors that my learned friend said were further factors on fairness, and the privacy conclusion was just 1 factor. I'd showed my lords and my lady why in fact 2 of those 4 factors were in fact privacy all over again, but in any event, privacy is absolutely the central plank of the judge's conclusion on fairness. So if my learned friend persuades you on that, the fairness conclusion also must be arguable, and certainly the judge's conclusion cannot stand because that was basically the key part of his analysis. It's very quick.
Commendably quick.
Yes. Oh, I'm terribly. I'm told I told you I'd give you the reference for Verity 13. It's in the supplemental bundle, tab 6, page 58.
Thank you.
I've taken that at breakneck speed, but that's, I think, everything I needed to reply on, unless my lord or my lady have any questions.
No, thank you very much.
Well, I promised to remind you about the Times application.
Well, the Times made an application, and I've had an email which seems to indicate that part of it has been dealt with. Is there an outstanding part? Does anybody know? No? Well, they asked for Mr. Matheson's statement, I believe, and for the... Yes.
My lord, my name is Jess Glass. I'm the representative of the Press Association. I hope my colleagues from the Times won't mind me speaking on their behalf. My understanding is that we've had Mr. Matheson's statement, but there's the outstanding matter of the texts referred to in Mr. Nell's statement. I believe I haven't seen the application, but I know that PA does support it from my colleagues who have seen it, just relating to the text, the schedule of the text.
The schedule of text.
Yes, or the text that referred to in Mr. Nell's statement that have been referred to in open court.
Right. Have the parties any views on this?
I'm going to pose the application for the text that the learned friend and myself were referring to first. The ones
Yes, I believe so. The ones that didn't hardly reference Mr. Nell's statement of the full text in their context would be much appreciated.
not those ones.
Not those.
I can pull up the part of Mr. Nell's statement if required.
I think there's a schedule of texts that was appended to a pleading.
I think, the Lord, the application was directed at the text that was supplied by Mr. Nell. Is that right? After the
emails.
Lord, it's texts and emails, I think, are next to Mr. Knauss' witness statement, is what I understood the application to be directed at.
They're not annexed, they came
They came afterwards, so that's why they're not annexed.
They came in what sense? And where are they in my bundle?
They will be in the application bundle at tab 5.
I mean, were they referred to?
Some were. I referred to about 4 or 5 pages. Probably.
Well, I'm looking at page 30.
Yes. I think I took the court to 31, 35, 37, 38 and 39.
Yes, you did.
Probably 40, 41 as well.
Yes, you did. Now,
And 43, I'm sorry, Lord, I'm interrupting your Lordship, 43 to 46.
39, 41, 43,
And 47, I think.
44, 45. You referred to a lot of them.
I did.
I see.
Supplied by Mr. Nauf and submitted to the court.
My lords and lady, if it assists, I believe my colleagues are referring to the texts and emails referred to in part 14 of the Duchess's witness statement that we received yesterday. So it is the complete copy of text and email communications.
It's not, I don't think.
Yes.
I wonder if I can...
Well, we haven't really been referred to the Duchess's witness statement at all.
No, it might help to cut through this. There's a slight possibility of confusion because the Duchess exhibits to her statement a fuller run of emails than Mr. Nauf provided. Not much fuller, but a bit fuller. So I suspect what the application really wants to get at is all the emails and all the texts. It doesn't matter whether it's in the form, perhaps, of those that are exhibited to the claimant statement or those that are supplied without an exhibit by Mr. Nauf. I suspect the parties between them can agree that. There's only one problem that Mrs. Phillips reminds me of, which is that the texts do include the full text of the letter, and not all of the letter was referred to by the judge in his judgment for good reasons.
No. So if the parties can sort it out, that's fine.
Yes.
If it seems to me certainly the letter should be redacted. If they can't sort it out by consent, then we'll deal with it in writing. It's not a rush, I don't think. As regards the case, did you have something you wanted to say?
Yes, my Lord, one very small point of correction.
Yes.
Paragraph 11 of the defence, page 319, admits in terms, and I quote, "It is admitted that the defendant did not contact the claimant before publication." I cannot assist, I don't have instructions on whether or not the defendant did contact Kensington Palace, when they contacted them, or whether that contact was even passed on to the claimant. But I base myself shortly and simply on paragraph 11.
Right, thank you very much.
I did give Your Lordship the reference to the defence where the contact is pleaded, which is 13.8.9,
Yes, you did.
page 329. Sorry, Lord, nothing worse than a fine.
No, I think we'll draw stumps, as we might say, now, and we will take time to consider our judgments in the usual way. We will hand our judgments down in due course in writing. When we do, you will please provide textual but not substantive corrections. The judgment will then be handed down remotely, and if you can't agree an order and costs and any consequential matters, we will deal with those in writing and not orally unless we otherwise direct. But may I thank counsel and solicitors for their helpful submissions, and obviously we will consider them with great care. Thank you.